What have you said? ಪ್ರದೇಶ ಆಗಿರುತ್ತೆ. ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ಹಾಲಿ ಜಮೀನಿನ ಸ್ಥಿತಿಯಂತೆ ರೂಢಿ ರಸ್ತೆ ಹಾದು ಹೋಗುತ್ತಿದ್ದು ಆಶ್ರಯ ಯೋಜನೆಗಾಗಿ ಕಾಲಿಸುವ ಪ್ರದೇಶದಲ್ಲಿ ರೂಢಿ ರಸ್ತೆಯನ್ನು ಕಾಯಂಗೊಳಿಸುವ ಬಗ್ಗೆ ನಿಮ್ಮ ಅಭಿಪ್ರಾಯ ಗ್ರಾಮ ಸಮಿತಿ ನೀಡುವಂತೆ ಮತ್ತು ಕವರ್ನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 133 130 ಹಿವಳಿ ಜಮೀನು ಆಗಿರುವ ಕಾರಣ ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಹಾದು ಹೋಗಿರುವ ರೂಢಿ ರಸ್ತೆಯನ್ನು ಕಾಯಂಗೊಳಿಸಿ ಸದರಿ ಪ್ರದೇಶ ಭೂ ಸ್ವಾಧೀನ ಪಡೆದುಕೊಳ್ಳಬೇಕಿದ್ದು ಇದಕ್ಕೆ ತಗಲುವ ವೆಚ್ಚವನ್ನು ಪಂಚಾಯತಿಯಿಂದ ಭರಿಸಲಾಗುವುದೇ ಎಂಬ ಬಗ್ಗೆ ನಿಮ್ಮ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ಸೋಣಿಸು. That's the only minute. Therefore, in fact,
yes.
therefore, not our request is not till they consider, not let them not close the or prevent us not from using this. Now the difficulty is not 3 days back they said because perhaps not it's some internal political issue possibly will not where between the government and the panchayat not something is seems to be. Therefore, not my main prayer is not is to consider and make it as a pakka road. Not and interim not I have said that let them not close or block or prevent the usage of this as has been not the customary usage which has been going on. In fact, not these leads to our local temples also.
No, in case all the villages, if there are some private land are ready to give up,
But they absolutely
to pull in some money. Whatever.
Absolutely not. We'll explore that also. Not
the council for the senior council appearing on behalf of the petitioner submits that the existence of a de facto the de facto usage
Rudy not perhaps customary or
de facto usage of
habitual, yes,
is not in dispute and comes out from a perusal of the report submitted by the ADLR to the Tahsildar.
Please.
It's however submitted that whether such road is to be formed by acquisition, it is submitted that the source of funds for compensation to be paid in the event of acquisition is a matter still to be decided. That being so, efforts are being made to block the usage of the de facto road.
Please.
In light of the contention raised and taking note of the report of the ADLR.
Please.
The respondents are directed to maintain the usage of the de facto road as the interim prayer.
Great.
EGA is directed to accept notice for the respondent. Chikkalapura Land Council MS Devraj accepts notice for the first respondent.
Great.
File this report along with the
No, we fill memo.
Lord, I had been to the corporation, my lord. They don't have a provision, my lord, to pay the amount. To plant the trees, my lord. I've taken a demand draft favoring the commissioner, my lord.
No, costs were directed to be paid to whom?
Through the corporation, my lord. Mangalore City Corporation. We went there, my lord. They say they are refused to receive it, saying that they don't have provision for planting trees. That's what they're saying, my lord.
What?
So,
no, one just one. What is this What was the order?
Was for
Order-
recalling the.
Recalling the dismissal order, my lord, dismissed for non-prosecution.
Ah,
That order was recalled, my lord, on cost of rupees 15,000.
ah.
Calling upon me to pay the amount to the corporation to plant trees, my lord.
Where is that order? Order dated?
I've taken a demand draft, my lord.
No, order dated,
Order dated, my lord, 25/3, my lord.
You appear for
Petition.
Bangalore City Corporation.
I appear for the
What
corporation.
is this kind of submission?
Lordship, the I,
Totally unacceptable.
No, I have
You
just-
don't plant trees, you
no,
don't
no,
maintain
I have
it.
just
If
contacted
there's a
the,
court order, you don't want to even at least show some sort of.
Lordship,
yes,
I've just contacted the corporation just now. They are stating that they have gone by cash and by virtue of DD. So they are asking for a challan because DD or cash would not be, they are agreeing to plant trees, but by virtue of a challan, if the amount could be received.
correct, that you work it out with them.
Yes,
Work
yes,
it out
Lordship.
with the counsel for the petitioner and see whatever is to be done, what he wants to pay, how he is to pay, that you work it out. with.
Please, please, Lordship.
So then we'll have it next week.
Yes, ma'am.
Huh?
Yeah, I've got a demand draft, my
So
lord. If they
that-
want,
that-
yeah,
that-
challan, my lord, I'll pay it by challan.
That you just work it out.
Yes, ma'am.
Please, Lordship. Great.
Relist the matter on dateful. 9th,
Can it be
Grateful,
10th, my lord?
10th,
10th, yes. 9th.
Huh?
Yeah.
16th. By then you plant the first sapling and you report.
Yes,
Yes.
that's better.
Grateful, Lordship.
Yes. No, don't grumble when we say now he's paying cost.
Yes,
The
please,
only
Lordship.
thing I've said, let the cost be appropriated towards some
Planting.
planting.
Obliged, Lordship.
Appear for the petitioners.
Yesterday only I received paravise marks. I will file my statement of
My lords,
short accommodation.
was finally,
Correct, you were directed to file.
Yes, I am directed to
Ah.
file the statement of objection.
Ah.
I have secured only yesterday in information, my lord.
Correct, so when will you file?
3-4 days.
Ah.
By Monday I will file.
Relist the matter in the same stage on
9th, 8th, my lords.
9th.
Nine, obliged.
Yes.
Appear for petitioner, please, Lordship. Amendment as petition was filed, please, Lordship.
You carry out that amendment.
I will carry out the amendment. Now, filing the writ petition, your Lordship,
Ah.
they have changed the Khata in their name. On that regard, I have sought for amendment. That was allowed. Here,
Give me the order sheet.
Lordship, the case of the petitioner, please, Lordship.
Let's let him, let's me make the submission. That's I appear for respondent number 5 to 7, my lords.
Yes.
By order dated 25/2/2025, my colleague's name was directed to be shown in the registry, my lords, but it was not shown. In any event, though we were on caveat. After that, my lords, when this matter came to be listed on 23/2025, they seem to have filed an amended application. Now we've got the copy of the amended amendment application and the old petition, my lords. The revised petition is not with us, or the amended petition is not with us, my lords. Now, my lords, if they can serve us the copy of the amended petition, we'll file our objection, my
You
lords.
serve it, I'll have it next week.
Let them, we'll file our objections in.
Taken up the matter on Monday, please. And serve it in the,
Copy of the.
and I may
amended
be permitted to
petition-
carry out the amendment.
Amended petition
Now it's
to be filed on council for respondent number
My lords,
private
respondent
respondent,
number 5
please,
to
Lordship. 5 to
7.
7.
5 to 7.
5 to 7. My name also.
And council so and so is undertakes to appear for the private respondents 5 to 7. Relist the matter on
Next week, my lords,
Next
post
week.
Wednesday.
9th.
Grateful, Lordship. I may be permitted to amend the cost.
Yes, yes. And file an amended petition. also.
Amended petition already filed, please, Lordship.
Filed.
Filed.
Petitioners permitted
Let's
to
may
carry out
request, my
amendment.
lords, to have it on 15th if it's okay.
On
It's only,
Allah,
Plausible.
my humble submission, they have
Hey,
already,
ಇದೇನ್ urgency
Allah, they
ಏನಿಲ್ಲ
have already
ಇದ್ರಲ್ಲಿ.
changed the Khata.
ಅಲ್ಲ,
but
ಖಾತಾ
they have not,
change ಆಗೋಗಿದೆ.
just now you undertake not to create third party rights till the next date. You're not going
Let's
to
we'll have
say
it on 9th.
9th. Yes.
My lords, appearing for the petitioner, my lords, kindly pass forward, my lords.
Who's R4? Yes,
That's all.
R4 was directed to take their stand in writing, isn't it?
R4 is a private party.
Have they filed?
Copy is not served on us.
Who's R4?
R4 is a private party, my lord. They have not taken any stand, my lord. I'm not sure if they have.
Plus
What was the
BBMP,
direction?
BBMP was assistant executive engineer was directed to, we were directed to present ourselves at 3:30 Malats. We have complied with that Malats. Inspection was conducted Malats.
You were supposed to appear before.
Yeah, we have appeared Malats.
You have appeared.
Yes, Malats.
Now
Kindly
what
pass
is-
over, I'll see further instructions. Malats.
Yes, Sanjeev, what happened?
They have appeared before the authority, my lord. The lady rang me up. She's at the work, my lord. Your lordship may give me a week's time, my lord.
Malats.
Find out. I think it will be done.
Malats, kindly pass over Malats. I think it's done Malats.
In fact, I talked to Mr. Suman, he also, to Siddharth. He said that they were already there. On Monday,
Malats,
or Tuesday, your lordship may come.
No, Malats, kindly pass over Malats. I've
So
received.
you must have, no, you can't ask for
Oh,
password.
Malats, actually, we've received instructions that
What? Relist the matter on the 9th in same stage. Yes. If you ask for password, it won't reach, so I'm going to adjourn. That's all. Lists are long. Yes, next.
Waiting for the petitioner, my lord.
Yes.
I'm
My
representing
lord,
respondent number 4 minutes.
page number 55 may be perused, my lord.
Just 1 minute.
It's, The contention, my lord, contention urged by the petitioner is that the respondent number 8 is putting up construction of the residential house without obtaining the necessary plan and license from the competent authority. My lords. On the previous date of hearing, the petitioner submitted that the planning authority, that is the fourth respondent, is the authority which has to sanction the building plan and license. But therefore, we lordships have said, my lord, to take a stand, my lord, in writing. That I have prepared the counter, my lords. I will be filing it within 3 or 4 days or within 1 week. May be taken up next week. My lords.
Now, is there a plan or no plan? What's the instruction?
Now, my lords, as regards the planning authority is concerned, the land where, my lord, construction is being put up is within the planning area. But the licensing authority is the local Gram Panchayat. When the plan and the license is sought from the Panchayat, Panchayat would grant the license. However, insofar as the building plan is concerned, they will send it to the planning authority for technical opinion. In the present case, my lord, no such process, my lord, procedure has been adopted. The plan is not sent to the planning authority for technical approval. And I'll put it in writing, my lord, that.
Yes.
My lord,
Why you have not served copy?
which copy? This one and somewhere. I'll serve it right now, my lord.
So then I can't hear you until you serve it on them. How can I hear you if you have not served on the licensing authority? Seventh respondent is the licensing authority.
Is a panchayat.
Is a panchayat.
It's panchayat.
But now there is no plan is.
No, my lords, I prefer respondent number 8, a private
Do
party.
you have a plan?
I have a plan.
Ah.
In the last hearing, I had a direction to file an affidavit. I filed the affidavit also.
My lord, one submission, my lord.
Just wait, let us.
Yes, yes.
You should have served it, no?
We have served.
If you don't serve on the panchayat authority, which is the licensing authority, he has no instruction. Now how can I ask him to take? Yes, what have you stated?
I have a plan approved by respondent number 7, my lords, and I'm constructing as per the plan. I have also submitted affidavit with respect to that. And also, my lords, this is not a fresh construction. I have an existing ancestral house, which I've demolished, and I'm doing a renovation of it. Since 1990, I've been assessed to tax from the Gram Panchayat. Even in my affidavit, I've given an extract of tax assessment register of 1990, my lords, at row number 16. As back as 1990, I had our RCC construction there, my ancestral house. The existing, it's only a plea for renovation of the existing building.
Let us see, relist the matter in the same stage on.
My lord.
9th, my lord, or 16th minutes.
On 16.
Please.
My lord, just one submission, my lord. It is true that they have a sanction plan, my lord, but he is not the authority. Respondent number 7 is not the authority to sanction the plan. They have to seek the technical this thing from the MODA, my lord. Then only they have the authority to sanction the plan, right? As of now, they have no authority to sanction the plan.
And-
This has been confirmed even by the reply from the Taluk Panchayat, my lord.
Let the planning authority file, then we'll see what is to be done.
My lords, I have one more submission. Petitioner is not an interested party at all. He is neither my neighbor.
He's not a neighbor.
He is not a neighbor at all. He is not a neighbor.
My lord, I'm not the
Not an
immediate
interested party
neighbor,
at all.
but
Because my lords, I would like to.
let me make a submission, my lord. I'm not the immediate neighbor, that is true, but I am the frequent user of that road, my lord.
No.
That road leads to our village, and the whole of village, that road has been,
This is not a public interest litigation for you. Let us see.
my lord, they have encroached the stormwater drain, my lord.
Maybe you have no authority or locus standi to question when you don't have a direct nexus to the property of being a neighbor. Let us see. I am not rejecting it now, but prima facie, you'll have to demonstrate your locus standi. What is your link with this property? Let us see.
Yes,
Now you take your stand in right here. Yes.
For respondent number 3, I'm filing statement of objection, my lord. May I request your lordships to have this matter on 9th, my lord.
What is this matter?
Lords, this is where we have challenged an order passed by the executive officer of the Taluk Panchayat.
So let us see what.
20.
27th March.
Lords, we had, sorry, I don't have the printout of that. We had referred to a suit judgment, my lords, subject to correction, I think your lordship said. Recorded about that suit.
Now the suit has been dismissed.
Dismissed. Suit filed by, my lords, the appellants before the Taluk Panchayat, and where the Taluk Panchayat had recorded pendency of that suit. My lords, mutation in my favor is challenged by third-party strangers, 4 to 6, in which they, my lords, not only mutation, they also allege, my lords, that I have encroached into a property. Now that suit is dismissed, in which all the parties are respondents. Now, unless that suit is decided, the Taluk Panchayat could not have given such a direction to, my lords, cancel the mutation and also, my lords, to remove the encroachment.
Now, the suit, you are a party to the suit.
Lord, Panchayat was party to this, my lord.
You appear for?
Panchayat, my lord, PDO, Panchayat Development Officer.
You are a party to the suit.
Please, my lord.
Then
Lords,
there,
my respectful submission, my lord.
there ends the matter.
Lord, my lords may kindly appreciate the, I have requested Mr. Vikram Wilgol to appear, my lord. He said kindly have it on 9th, my lord. Or I will request lordships to pass over or on 9th, my lord.
I'll pass over, let us see. Pass over.
I filed a statement of objection today.
Let us see. Now,
Very good.
if you have suffered a decree,
Lord,
that is conclusive as of now. These are proceedings on the revenue side. That is subject to the, that will have to be subservient to the.
It's
only
not a
the
suo moto action by the Panchayat.
That is not only the issue, Lord.
Lords,
because-
that's the
Pass
issue.
over, pass over.
Very well.
This case paper for petitioner, my lord.
Yes.
In this last occasion, this honorable court issued notice to the that, proposed respondents, my lord.
Lord, I beg to appear on behalf of my lord, the proposed respondent, undertakes to file work. Undertakes to Bank of Baroda, my lord.
So now what has happened?
Worship, the case of the petitioner is that the adjacent owners has put up construction and there is no retaining wall. Actually, the construction was is underway, like for last 2-3 years, and no further construction has been done. Actually, what has happened, there is a joint development agreement between the developer and the owner. Then they didn't put up the, they didn't completed the construction. Then they have filed a OS suit against each other in OS 5086 of 2020. So though no further construction is going on, and the owner is also not interested.
It's abandoned.
Yes.
Now, what is the threat of the petitioners
Now,
are?
there is no imminent threat. The construction has come to a standstill.
Huh?
Construction has come to a standstill. Last time I have produced the photographs also.
Yes, what?
Kindly see the page number 58, my lord, photographs furnished by the petitioner. They have not put up the construction wall, that protective wall around the apartment, in spite of my repeated request to the owners and builders. Since that is,
You appear for?
My lord, I beg to appear on behalf of my lord, respondent number 5, Bank of Baroda. Recently, my lord, we received a notice. Subsequent to they filed an impleading application. I sold a property pursuant to my lord surface action.
Who's the purchaser now?
Satyanarayana Education Trust, my lord.
Now you place it on record. You file a memo.
Please, my lord, I'll file a sale certificate.
Now you'll have to implead the purchaser.
I have already implemented, and this honorable court already issued notice to that respondents, my lord.
IA for impleading.
Please, I have already paid process fee. This honorable court already issued the notice to the proposed respondents, my
Please
lord.
to put up report regarding
Please, IN number 1.
is issued to proposed R3 to R6. Relist the matter. Date code. Let him come, then we can give some direction to.
Please, my lord.
Yes.
Grateful. My lord, my appearance may be recorded in respect of respondent number 5, my lord. Vignesh Shetty. I understood, my lord, I am.
To show the name of learned counsel so and so as representing respondent number 5.
Grateful.
And appear for the petition. Notice is served.
Pertains to land acquisition, my lord.
Or the report, my lord, of the
Compensation in this case, my lord, it doesn't come under LB, local body.
Huh?
It pertains to land acquisition. Their prayer is for land acquisition.
No, who has made the road now?
my lord, the Department of RDPR, my lord, through the seventh respondent, eighth respondent.
Who's the eighth respondent?
That's the
Gram Panchayat.
Gram Panchayat. Routed through, my lord, the Zilla Panchayat, sixth respondent also. Notice is served on all of them.
Manjuna, PDO Chitradurga.
But I have also taken out, my lord, hand summons upon the, and have served, my lord, on.
Now you find out, Bopanna, you find out. Somebody must represent the eighth respondent. I'll have it.
Praveen Kumar. Praveen Kumar has applied.
Learned Counsel Praveen Kumar is directed to accept notice for the eighth respondent. Now the road is formed by the eighth respondent.
Road is formed, my lord, through the RDPR department. That is the second respondent state. My lord, there is a correspondence, my lord, between the state government and the deputy commissioner of the district. And that is, my lords will find, my lord, at the last of the documents. Annexure G, my lord, dated 13/9/2024. Annexure G at page 93. Next page, my lord, 94, last paragraph. The deputy commissioner, my lord, has communicated to the second respondent RDPR department to take action, my lord, in accordance with law, insofar as the 23 guntas of land which is used for the formation of road. In that, the road, my lord, which comes under the jurisdiction of the eighth respondent. Last paragraph, my lord, in that. Page 94. May I read, my lord, last 2 lines. Hagu Sadri Jaminil survey sketch nante 23 ಗುಂಟೆ ಜಮೀನು ರಸ್ತೆಗಾಗಿ ಸಾರ್ವಜನಿಕ ಉಪಯೋಗಕ್ಕಾಗಿ ಬಳಕೆಯಾಗಿದ್ದು ಸದರಿಯವರಿಗೆ ಈ ಹಿಂದೆ ಆಗಲಿ ಹಾಲಿಯಾಗಲಿ ಪರಿಹಾರ ಕೋರುವ ಕುರಿತು ಸೂಕ್ತ ನಿರ್ದೇಶನ ಕೋರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ತಮ್ಮ ಅವಗಣನೆಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. Thereafter, not the.
Just one. But page 94, third paragraph. 11/1/2024 ರಂದು read that.
Please, my lord. 11/1/24 ರಂದು ಕಾರ್ಯಪಾಲಕ ಇಂಜಿನಿಯರ್ ಯೋಜನಾ ವಿಭಾಗ ಚಿತ್ರದುರ್ಗ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ಪ್ರತಿ ವಿಧಾನಸಭಾ ಕ್ಷೇತ್ರದಲ್ಲಿ ತಲಾ 30 ಕಿಲೋಮೀಟರ್ ವರೆಗೆ ಗ್ರಾಮೀಣ ರಸ್ತೆಗಳನ್ನು ಪ್ರಧಾನಮಂತ್ರಿ
ಗ್ರಾಮ ಸಡಕ್ ಯೋಜನೆ ಮಾರ್ಗಸೂಚಿ ಹಾಗೂ DRRP ಅಲ್ಲಿರುವ ಗ್ರಾಮೀಣ ರಸ್ತೆಗಳನ್ನು ಕರ್ನಾಟಕ ಗ್ರಾಮೀಣ ಅಭಿವೃದ್ಧಿ ಸಂಸ್ಥೆ KRRDA
No, so will this come under local body or how?
It comes under local body.
Okay, then you get instructions. Now the government only, now this scheme is by central government.
The same allowed, this road is formed not under that scheme.
Which scheme, the scheme is by whom? State government or how is it? Is there any project? Executive engineer of the project will be in charge.
Yes, my lord, I'll take instruction.
You find out and then you mention who is the concerned, then let him implead. AGA to state if any other authority is to be arrayed as a respondent in light of the observations in the proceedings dated 13/9/2024 at Annexure G. This is the matter in the orders list.
The executive engineer, my lord, has been made as respond number 9.
Correct, but there may be some project and that project directly
Please,
have to be made.
Please,
Let him find out.
Please.
Release the
Any date, my lord? 16, oblige.
Before respondents, my lord, I pray for 2 weeks' time, my lord. Pursuant to a decree, my lord, petitioner is seeking Khata. File is misplaced in the office of the ARO, my lord. They want 2 more weeks.
release the matter
For the petitioner,
date.
Please.
The second, you find out.
Please.
You give him some extra copy if he wants, just give him.
No, I have the copy.
third copy, sir.
Office has misplaced the ARO office.
There is a representation that we have given following a decree, Your Honor.
But now then you rebuild it. If there's a decree.
No, they are searching, my lord. It appears it has been sent to the estate office, my lord. They are going to get it. Please.
Yes.
Yes. Your lordship had stayed the auction and asked us to appear before the respondent BBMP on 24th. We've appeared and given a representation. In fact, Mr. Pavan was here. He was asking us to meet yet another officer. We will meet him tomorrow. It could be had on Monday, my lords.
Release the matter in the same stage on.
Grateful.
Yes.
This is a matter, my lords. I had filed it on 5/7 till date. They have not granted me the permission. For the sanction. Lords, under the section 15 of the Town and Country Planning Act, there is a deeming provision wherein within has not communicated its decision within a period of 3 months, my lords.
Section
15 of the Town and Country Planning Act.
My lord, must not serve, my lord.
No, I have already served.
No, my lord.
No, you serve, correct, sir.
Put it there.
Serve.
No, sir, only name is not showing.
Just 1 minute. Now serve him one more copy.
I will do it. I'll do it here. And now.
I'll have it on Monday or Tuesday. Serve him one more copy.
I'm just giving it here and now, my lords. I'll give it to him.
He'll list the matter on 8th.
Yes. Lords, in the meantime, my lords, at least can I clear it, my lords? Because once the monsoon starts, it becomes very difficult for me, my lords. I'll at least do the clearing. And whatever I have to do is only subject to what it should be in accordance with law and the bylaws. I can't do anything beyond that.
Let us see. Now you find out
Yes, ma'am.
if they've given for a plan,
Yes, ma'am.
you have to take your stand, approve it. Whatever he has to fulfill, he will fulfill.
I'll find it on my lord.
Huh?
Find it and release that. Just a matter of date.
Let us see on the next date.
Okay, ma'am.
Relist the matter.
Lords, the copy is served, my lords. Let it be recorded, lest they come and say next day.
I will.
Eight.
Great. Great.
Then for petitioner, my lord. Annexure A is the order, provisional order passed by the respondent number 2, my lord. Without giving any notice or without, they have passed an order stating that merger has been conducted. But no merger has been conducted. and no notice has been given to me.
What have you put up now?
Ground floor, my lord. Ground floor shop is there. 600 square feet shop is there.
How much?
600 square feet. Property is measuring 900 square feet. One shop is there.
But then you must take a plan, isn't it?
I will.
Construction is complete or not yet?
Yes, madam. Only floor, ground floor is completed. No more further construction, madam.
Now let him apply under 248.
Yes, madam.
It's a case where it's the property that they have constructed is just below the high tension wire, my lords.
High tension.
So a plan cannot be sanctioned. Already provisional order is passed. We have asked them to stop the construction because it's just below, and there is some dispute that residents have complained that it comes under CS site.
No, that's a different matter. Now if it's under high tension wire,
Sanction cannot be given.
then you take your stand in writing. Take your stand in writing. Now if it's under high tension wire, how you can put up construction?
So it has been gifted by my father.
No,
They have constructed.
That's what we have stopped at.
Commercial shop they have constructed.
Only one shop is there.
Correct. Under high tension wire, you cannot put up construction.
Just below it.
You can't.
We have asked them to stop further
If any
construction, but some
accident
work is
happens,
going on.
nobody who's going to be responsible. This cannot be done.
Lord, let them conduct a proper survey and give report, my lord, on that.
Let him appear before you. Now 248(3) order is not passed.
Not yet passed.
Isn't it?
Yes, my lord.
Let him appear before you and let him say whatever he wants. Before you pass 248(3) order, you consider it. I'll keep it or we'll dispose it off.
Dispose it off also, but let them not put further construction.
No, we are not putting any further construction. We are not putting any construction, my lord.
Some interior work there.
Then go and appear before under 248(3). Don't no further construction. I'll pass that till this issue is resolved.
Yes.
And dispose it.
Yes, my lord. Not
You
to
can't
take
get a plan under a high tension wire.
Yes, my lord.
Huh?
Yes, yes, my lord.
It's risky for
That's all.
them.
So what we can do?
It's risky for them also.
The petitioner. You must educate your client.
Yes, my lord.
Petitioner has sought for setting aside of the order. Provisional order under 248(1).
1 and 2, both are passed.
1 and 2.
The notice. 1 is the order, isn't it?
2 is the show cause notice, 1 is the order.
Under 248(1). Whereby the respondent BBMP has pointed out that the construction is illegal. It is noticed that notice under 248(2) has been issued. Petitioner has approached this court at this stage. Pursuant to the notice under 248(2), petitioner is at liberty to put forth his stand and explain as to why the provisional order under 248(1) need not be made absolute and confirmation order be passed under 248(3). Accordingly, we find that the present petition is premature. It is also noticed that under the order under 248(1), there is already a order of restraint not to put up any construction. Needless to state, petitioners to be bound by such order of restraint till the same is varied by the respondent BBMP. Accordingly, petition is disposed of. All contentions raised herein are kept open to be raised before the respondent BBMP appropriately. Respondent BBMP to hear the petitioner, take note of the objections if filed within 10 days from date of receipt of order and proceed further as regards the proposed order under 248(3). Accordingly, petition is disposed of. Within 10 days, you have to file whatever objection. ಜಾಸ್ತಿ ಇದೆ officer. Huh? Weeks time granted for necessary compliance. Yes,
18, Naveen GS.
My lords, a week's time may be granted, we'll comply with
time
it.
granted for necessary compliance if office objections are cleared, list the matter in the fresh matters list on 15th. Yes,
Grateful, my lords.
19,
By Monday, I'll comply, my lord.
office
Kindly have it on.
objections to be complied with. If office objections are cleared, list the matter in the fresh matters list on
7,
7th.
20,
Yes.
By the writ of Mandamus, Your Lordship. Nasher B is the gazette copy. You are not relied upon that copy. Your Lordship. So blur ಆಗಿದೆ. Writ of by the writ of Mandamus. Annexure E and F.
Learned counsel for the submits that the copy at annexure B
Annexure B, Your Lordship. Gazette copy of the
is produced only
verification.
for reference. In light of the same, the
Directing the second respondent to
objection is kept open, kept in abeyance. Now what is the relief?
Annexure B, Annexure E and F, Your Lordship. The formation of national highway, Nenmangala and Kunigal Road use, formation of national highway, Your
So
Lordship.
you are seeking for
Only for directing the Khata in favor of the petitioner, remaining portion of the, after acquisition of the national highway.
you take out notice.
Yes, Your Lordship.
And MS Devraj for respondent.
Third counsel, MS Devraj is directed to accept notice for the second respondent.
Second response.
AG accepts notice for the first respondent. List the matter in the preliminary hearing list after 10 days. Date good. They are only asking for Khata, you find.
Yes, Your Lordship. Remaining portion only after acquiring the highway, remaining portion to be Khata in favor of the petitioner.
16th, yes.
21, serial number 21, Jaikar Shetty.
For the petition, weeks, kindly 1 week's time.
Huh?
Office objection.
Weeks time, huh?
Week's time.
Last occasion, the copy is not served, my lord.
ಇಲ್ಲ ಅದು
Copy not served. Last time a direction again.
Serve copy is
today I have sir.
weeks time granted for necessary compliance of the office objections. Copies to be served on the caveator.
Yes.
20,
Yes.
22, Nishant.
Seek for a pass over, my lords.
What is the matter?
My lords, this is with respect to allotment of site, my lords, wherein the allotment we made, which in my favor was cancelled. Annexure G, my lords, page number 25.
Have they filed their objections?
No, my lords.
Okay, pass over. Let us see if time permits. Pass over.
Please, my lords.
23,
Paper petitioner, my lord. Week's time may be granted.
Weeks time granted for necessary compliance. Yes.
Interim order, my lord.
Interim order and operation is extended till the next date.
24,
Wherein the petitioner seeking the quashing of annexure, the endorsement issued by the respondent number 2, the non-issuance of the Khata.
No, now who's answering respondent? PDO.
PDO respondent number 2 already has
Praveen Kumar.
already has served the copy and
Praveen Kumar. Third
ಇಲ್ಲ
counsel
ಪ್ರವೀಣ್
say-
ಕುಮಾರ್ ಅವ್ರು ತಮ್ಗೆ ಸಂಬಂಧಪಡಲಿಲ್ಲ ತಾಳಲಿಲ್ಲ ಕಳ್ಸರಿ
Huh?
ಕಳೆದ ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರವೀಣ್ ಕುಮಾರ್ ರಿಸೀವ್ ಮಾಡಲಿಲ್ಲ ಬೇರೆ ಯಾರಿಗೂ ಇದು ಮಾಡಿದ್ರು ಬೋಪಯ್ಯ ಅವರು
ಯಾರ್ ಪ್ರವೀಣ್
ಆಲ್ಟರ್ನೇಟಿವ್ ಆಗಿ ಬೋಪಾಯಿ ಅವ್ರು ಬೇರೆ ಏನೋ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಿದ್ರು ಅವರು ಅವರ ಗವರ್ಮೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇದು ಮಾಡಿ.
ಅಲ್ಲ, they are saying Praveen Kumar, you have to serve.
ಅಲ್ಲ ಪಾಸ್ ಓವರ್ ಇರ್ಲಿ ಬೋಪಾಯಿ ಅವ್ರ ಹತ್ರ ಒಂದು-
Pass over, you find out, pass over. Collect the Praveen Kumar's phone number and just find out.
ಇಲ್ಲ, ಅವ್ರು ನಾವು ಕನ್ಸಲ್ಟ್ ಮಾಡಿ ಹೇಳಕ್ಕೆ ಅವ್ರು
ಅಲ್ಲ ಆಯ್ತು, ನೋಡ ಅವ್ರ ಫ್ರೆಂಡ್ ಇದಾರೆ ನೋಡಲ್ಲಿ.
ಅವ್ರ ಥ್ರೂನೇ ನಂಬರ್ ತಗೊಂಡು ಮಾಡಕ್ಕೆ.
25. The petition.
And for the impleading.
They are
applicant,
filing the impleading application, copy is not yet served, my lordship, in this case, on Ashwatthappa.
when did you serve?
Therefore, I request this respondent counsel to serve the
But
copies to
2
the
weeks back only copy
petition.
is served.
Lord, the petition.
Nevertheless, we'll serve one more copy. That's not an issue.
He instructed me, sorry,
Oh,
sorry, no, no,
Copy
taxi
survives.
counsel, sorry.
But the only issue is they have made certain comments in the body of the writ petition itself, taking my name individually. I want to come on record and assist the court.
The petition copy is not served, my lord, to regard.
Huh?
Petition copy is not.
Writ petition copy, you give it to R2, who's answering respondent?
Answering respondent is
R2.
R2.
Huh?
Yes,
In this case,
R3 order has been challenged in this petition.
Annexure A, my lord.
No, R3 is represented by state.
State. Commissioner of Panchayat Raj has passed an order,
there is no
Lord,
law.
appointing a fact-finding committee, whether there is any deviation as regards the CA sites in a particular area. And that order has been challenged by the developer.
And locus standi to file the petition. This is the committee formation though. Next year, kind of similar.
So let us see, you take your stands in writing. Let us,
They have already filed the application.
your file.
Yes.
My application for impleading may be allowed. Because at para 10, they have taken my name. Para 10, page 12. I am Mr. V.L. Bharatraj.
Don't repeat the allegation.
I am not. So therefore, para 10 and 11 both.
So let us see, at the time of hearing, we'll consider.
Yes.
Please.
Now the state.
Then 232 capital. Now the state.
Lord, this one is waived, my lord, on 1997, my lord. And based on, my lord, complaint, my lord, this committee formed because, my lord, CSI's parts should be relinquished to the authority, my lord. It cannot be used, my lord, to.
Even for CSIs.
Something.
Panchayat has issued a khata to the CS sites as well, and that has been sold to other persons by the developer who is before the court as a petitioner. Now either he has to purchase additional parcel of land and earmark it, or do some activity of reconveying the land. Now that's why the fact-finding committee has been appointed. The question is whether that power exists with the commissioner to name such fact-finding committee. That's the scope of
The take their stand in writing within 10 days. 2 weeks. Relist the matter on date good.
Copy may serve.
21st.
That copy may serve, my lord, to read.
Serve copies
Writ
immediately.
petition copy is served. I will inform the D. Ashwatthappa, serve the copies to the government.
ಅಲ್ಲ ಆಯ್ತು, ದಿನ ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ.
ನಾನು ಕೊಡ್ತೀನಿ.
Yes.
Number
and I may be permitted to carry out some amendments. There are some office objections, I will comply.
The
Amended
counsel for
petition,
the
they have to serve.
impleading applicant is permitted to rectify the office objections raised on the application.
Please.
on A.
Yes.
And also amended petition. may be served.
ಅಲ್ಲಿ ಇನ್ನೂ ಅಲೋ ಆಗಿಲ್ಲ,
Agil,
ಬಟ್ ಕಾಪಿ ಕೊಡಿ
please.
Thereafter,
26,
ಅದ್ ನೋಡಿ ಅದು.
Time of hearing.
They are supporting you. Yes,
serial number 26,
weeks time granted to take necessary steps.
27,
If we take up some of the, just, but no, it was
respondent in this case.
recently have come on record.
Request on behalf of the petitioner, relist the matter Office to strike out delete the name of learned counsel R. Badrinath as learned counsel, H.T. Natraj as put in appearance for the petition.
Please. 28.
I'm for the petitioner, madam. I'm filing affidavit in this. Filing affidavit of ADLR.
Just I received, madam. Report just I received, madam.
Affidavit by
Union
the
direction.
Assistant Director of Land Records is placed on record. We'll have it next week.
Madam, one submission, madam. Clearly, one more directions to the government, madam, wherein your lordship observed that learned AGA also to take their stand in writing regarding the land in which construction is being made belongs to whom?
The
Last paragraph, madam.
Last date of hearing.
Order dated
Order dated 12/2/2024. 12/2/2024, madam.
Last paragraph.
Last paragraph.
Have you taken such stand in the
In
affidavit?
this, my lord.
You have
Thereafter, report has been filed, my lord. After
Specific-
filing the report, my lord, the honorable court has directed to file an affidavit.
You have explained this aspect also.
Clear.
Have a look at it.
What
Have a
happened in
look
this, my lord? ADLR has no records in their office, my lord. There is no survey number in the land. The answering, the authority is, my lord, the corporation.
So I filed my objections in vacating
All the
state.
records with the corporation.
And if I may, my lords, the petitioner herein had also filed a contempt, saying that I have violated the directions of this honorable court. The contempt is also disposed of, holding that there is a plan and there is a approval for the said construction of the school, my lords.
Now let us see. Have a look at the affidavit. We'll have it next week.
Please, madam.
Affidavit filed by the Assistant Director of Land Records is taken on record. Relist the matter on date code
23.
23rd.
Please. Number 29. Rajendra MS Devraj.
Petitioner, my lords. I'll serve the copy in course of the day, my lords, to MS Devraj.
Respond number 3 is considered, I'll accept not.
Of the day,
R3 is consent, I'll accept not.
Learned Counsel Shri M.S. Devraj undertakes to appear for the third respondent. So what is the matter now?
my lords, I'm the
Copies.
Copy now ಕೊಡ್ತೀನಿ ಅಂತೀರಿ.
Serve copies.
yes, my lords. Course
Copies
of
to
the
be
day.
served on counsel for R3. You're challenging an order of 2011.
Yes, my lords.
Serve copies, serve copies. Statement of objections to be filed by the respondents within 2 weeks. List after 2 weeks. Let them file, then you move the matter. Yes.
30. Serial number 30. Rajshekhar.
Yes.
The petitioner, my lord, will take steps, my lord. A week's time may be granted.
Time granted to take necessary steps. Yes.
31.
My lords, I appear for the petitioner's matter, my lords. A week's time may be granted, my lords. I'll take necessary steps.
To take necessary steps.
32. Ajit PB. I'll take necessary steps.
Week's time granted to take necessary steps.
33.
I was directed to place on record, my lord, an inspection report. Serial number 32. I'm just placing that on record, my lord. Along with a copy has been served to.
What is this matter?
Lord, regarding deviations in respect of a property under construction, my lord.
Petitioner is the complainant or he's?
No, my lord.
The respondent is the.
The respondent is the person, my lord, who is
respondent number 1 to 4, my lords.
1 to 4.
1 to 4. So in violation of the sanction plan, they had.
In fact, there is no
Corrected.
sanction plan.
Correct. Now, construction is complete or still going on?
Lords, there was an interim order by this honorable court to stop the construction. So it is stopped.
Stop.
Stopped.
So let the notice be complete.
Yes,
Huh? Now this checklist is what you have prepared, is it?
Please, my lord, it was as per the directions of the coordinate bench of this honorable court, my lord. So for which, my lord, I had to.
At an inspection, this is what you look into.
Yes. So let them also go through that, my lord, and if at all they have anything to submit as against this report.
The statement, status report by respondent BVMP is taken on record. Relist the matter after 2 weeks. Now you want to take out notice by hand summons?
No, my lords, it go through by.
Through court.
Through court.
Steps to be taken for issuance of notice to R3. Yes.
33, Chandrasekhar N.
An identical case, my lord.
33.
Yes.
33, this is not your case. 33.
I'm finished, my lord. Chandrasekhar.
You are filing memo of retirement. No, you have filed a memo of retirement or what?
Yes, my lord.
Memo of retirement ಹಾಕ್ತಿದ್ದೀರಾ? ಹಾಕಿದ್ದೀರಾ? ಹಾಕ್ಬೇಕಾ?
ಹಾಕಿದ್ದಾರೆ.
But have you served notice to your party?
BBMP executive report ಬಂದಿಲ್ಲ.
No, that is there, but you have filed a memo for retirement.
ಇಲ್ಲ.
Then you have to produce acknowledgement for having intimated your client. That will take note of.
That is something he's saying that he's.
ಏನು ಹೇಳಲಿಲ್ಲ.
So then we'll close it. The petitioner has signed.
My lord.
We'll take and close it.
Very well.
R6 and 7.
My lord, I think there is some.
No, both are
Chandrasekhars.
The counsel for respondent 6 and 7 has filed memo for retirement. There is intimation for the said respondents. Office to show the name of respondent 6 and 7 in the cause list as served, as the respondent 6 and 7 have been intimated. Question of issuing further notice to R6 and 7 does not arise, and respondent 6 and 7 would bear the consequences of not making arrangements of being represented by a legal counsel. The report memo along with report is filed by respondent BBMP. It is noticed that in terms of the report, there have been deviations. In light of the same, the respondent 6 and 7 are restrained from putting up any further construction. Respondent BBMP is at liberty to ensure that there is no further construction and may take the help of the jurisdictional police to enforce such interim order. Further steps to be taken by respondent BBMP under 248. List the matter after 2 weeks.
34. Sir, 34 Joseph.
Appearing for the petitioner, Your Lordship. Your Lordship, we have taken process as regards proposed respondent number 7 to the correct address today. Matter may kindly be had after 1 week, Your Lordship.
It is submitted that steps have been taken for issuance of notice to proposed R7. Office to verify and issue notice. Yes.
Thirty-five. Ravi Shankarge, Vivekananda team, Anand.
This is a matter where I sought for Mandamus, and my learned friend wanted to also join the as an impleading applicant and try to expand the scope of Mandamus. In the meantime, Muda has filed their memo indicating the extents of land that is occupied by me and the impleading applicant. And they say that if my lord were to take the sketch that they have produced.
No, what is the matter?
ಅದಕ್ಕೆ ಈಗ ನಾನು I also don't want to expand the scope of my own petition. If my lords, I will be happy if my lords were to direct me to go before the Muda. That's all that I ultimately sought in my petition.
Impleading applicant also filed a separate
Impleading application, let him.
I'll already file list. List number 2, serial number 3.
So far as I am concerned, they have given me a site number 18. Now Muda is saying that there is a less extent of land. All this can be sorted out by me also joining in the survey. But let the Muda take a call on this.
Yes.
That's the, initially, my lord, the writ petition is filed seeking writ of Mandamus to consider their representations in terms of the resolution passed in the year 2008, by which decision was taken to allot about 2,880 square meters of marginal plot, which is adjacent to the CA site allotted in favor of the petitioner and adjacent to the petitioner in the connected matter, which is listed in list number 2.
Both are neighbors.
Yes, my lord. Neighboring CA site allottees.
Authentic.
The lordships could see the memo filed by me on 27th March 2025, which would give a clear picture of the position of the sites.
Yes, read the memo.
Please, I'll read. The petitioner has filed the above petition seeking direction to this respondent to hand over possession of area measuring 2,880 square meters situated between CS site number 18 and 19, Vijayanagara 2nd Street, so and so. It is the contention of the petitioner that pursuant to the resolution dated 22/11/2008, this respondent through communication dated 28/1/2009 had called upon the petitioner to pay a sum of rupees 8,64,000 towards the allotment of aforementioned marginal land. Accordingly, the petitioner has deposited a sum of rupees 8,64,000. However, so far.
No, now, so you have stated that the request would be placed before the board for appropriate decision.
Isn't it? Yes, madam. But your lordship could kindly simulate the sketch enclosed to the memo.
Yes.
That's the portion marked in blue is the CA site allotted in favor of the petitioner, and the CA site number 18 is allotted in favor of the impleading applicant. That in between two sides, the area marked in yellow and gray is the area which is available for allotment as a marginal plot, because in taking note of the frontage of the plot, it cannot be used as an independent COA community site. It is in that context that the request of the petitioner was considered earlier. Now the allottee of CS site number 18, that is the impleading applicant, is also claiming that out of yellow portion area, he has to be allotted 50%. Now both the applications will have to be considered by the board. Earlier, decision was taken to allot entire yellow color portion in favor of the petitioner.
No.
One second.
Just wait.
Please. It was taken a decision. However, in the subsequent board resolutions, which was not ratified, they said the spot inspection is to be conducted and necessary report is to be obtained. Now the present report depicts that in respect of entire yellow color portion, the petitioner has already put up compound wall. Therefore, while considering the request of both the allottees, the authority will have to take a call to bifurcate yellow color portion of the area into two parts. one portion in favor of the impleading applicant, other portion in favor of the petitioner. And the area on the eastern side, my lord, on the eastern side.
The court will not enter into
Yes,
that.
it is for the authority to take a call, my lord.
We will only say that matter would be placed before the board, which is to take appropriate action as per law.
Please.
ಅಷ್ಟೇ ನಾನು ಕೇಳಿದ್ದು.
Impleading application also filed a writ petition, so it is listed in serial number.
I'll take that also. Adu kodu.
Same.
Petitioner. Huh? So we'll dispose of this petition stating that matter would be placed before the board. Board may take appropriate action in accordance with law. His same relief or what is?
Same relief, same relief.
Same prayer, my lord, is for consideration of the representation to allot the marginal plot in between CSA
Same
number 18 and 19.
Okay, that also you consider.
Both. Only one submission.
What is done is done. If there's already a resolution, whatever, that you may have to work out whatever is.
Lordship, may kindly take note of the communication addressed to me by the authority, page number 3 of the memo. The contents of the memo is virtually extraction of the instructions which I have received. Lordship, may kindly take note of it.
I have only one submission to make. There is a map that my learned friend has given. ಅದನ್ನ ಯಾವುದನ್ನ accept ಮಾಡ್ಕೊಳ್ಳೋದು because we were not given any notice. Let them decide again, giving us an opportunity. ಅಷ್ಟೇ ಕೇಳಿ.
Yes.
Only one submission. Make one submission. Lord, my learned friend, the petitioner is seeking a mandamus based on the resolution dated, Lord, on 22/11/2008. It was their case that there was a resolution for allotment of 2,280 square meters, Lord. But I have produced such resolutions, my lord, along with my impleading application. No, they have only passed a resolution saying that decided to allot both the parties. They have not decided the measurement is concerned. I have produced that resolutions copy along with my impleading applications, my lord. This is in page number 6, annexure, page number 17, annexure R6. And subsequently, my lord, as per the resolution dated.
So where is it?
My lord, relevant portion in page number 18, my lord. Second para, my lord. First para, I may permit a person. ಸದರಿ ಸಭೆಯ ನಡಾವಳಿಗಳನ್ನು ಅನುಮೋದಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ಆಯುಕ್ತರು ಮಾತನಾಡಿ ದಿನಾಂಕ 15/9/2018 ನಡೆದ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯಲ್ಲಿನ ವಿಷಯ ಸಂಖ್ಯೆ 51 ಅಡಿಯಲ್ಲಿ ಕಾವೇರಿ ಚಾರಿಟಬಲ್ ಟ್ರಸ್ಟ್ ಮತ್ತು ಚಿಕ್ಕಮ್ಮ ಶೈಕ್ಷಣಿಕ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆ, ದಟ್ ಇಸ್ ದಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್, ವಿಜಯನಗರ 2ನೇ ಹಂತದಲ್ಲಿ ಅನುಕ್ರಮವಾಗಿ ಮಂಜೂರವಾಗಿರುವ ಸಿಎ ನಿವೇಶನ 18 ಮತ್ತು 19 ನಡುವೆ ಹೆಚ್ಚುವರಿ ಜಾಗವನ್ನು ಮಂಜೂರು ಮಾಡುವ ವಿಚಾರದಲ್ಲಿ ಸುದೀರ್ಘ ಚರ್ಚೆಯ ನಂತರ ಸದಸ್ಯರುಗಳು ಸ್ಥಳ ಪರಿಶೀಲಿಸಿ ನಂತರ ಅಂತಿಮ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳುವುದು ಸೂಕ್ತವೆಂದು ತಿಳಿಸಿದ್ದು, ಈ ಪ್ರಕರಣ ಇರ್ತಕ್ಕೆ ಬಾಕಿ ಇದೆ ಎಂದು ಸಭೆಯ ಗಮನಕ್ಕೆ ತಂದರು. There is no resolution regarding allotment of 2,880 square meter in favor of the petitioner. Only their resolution. Subsequently, I produced the page number 7, annexure R7, page number 19. This was kept in abeyance in the subsequent resolution dated 11/2/2009. Relevant portion.
But they are saying this resolution has not been ratified.
Please, not kept in abeyance.
No, resolution is not ratified. Is
please. But my learned friend say that this resolution, in the said resolution, there was a resolution saying that allotment of 2,000.
The entire issue is open.
Place your matter before the board.
Please.
The petitioner has sought for issuance of a writ in the nature of mandamus to direct respondents to convey and hand over possession of the property described in the schedule in terms of the resolution dated 1/6/2009.
Ouch.
1/6/2009.
Resolution.
And in terms of the demand and in terms of the notice at annexure C wherein a demand has been made. Third counsel for the answering respondent, that is Muda, has filed a memo which reads as hereunder. In light of the same, petition is disposed of observing that the respondent would place the request of the petitioner as also the impleading applicant before the board, which would take an appropriate decision. All contentions on merits of petitioner and impleading applicant of the petitioner and impleading applicant are kept open.
One time frame.
Once the matter is placed before the board, necessary decision to be taken within a period of 3 months.
Which may grant us 4 months, Malad, if it is.
6 months. Not later than
4 months, will
4 months from date of receipt of certified copy of the order. Full stop. As the request is by the petitioner for consideration of his request. Question of granting any relief to the impleading applicant in the present proceedings does not arise, and accordingly the application of the impleading applicant is disposed of as not calling for any further orders. Full stop. Next, the petition has been filed seeking for a direction to respondent number 1 to consider representations of the petitioner trust and issue a direction to respondent number 1 for allotment of marginal land situated between CA site number 18 and 19, Vijayanagara second stage, to the petitioner trust. And Counsel CTP Vivekananda, appearing for the first respondent, submits that a memo has been filed in WP 16015 of 2024, and the contents of the said memo may be taken note of in the present matter also. That one copy, can you place it?
I'll place it.
Peruse the said memo. It is noticed that it is a case of the respondent Muda that the request of the petitioner would also be placed before the board for appropriate orders. In light of the same, petition is disposed of taking note of the contents of the memo. All contentions of the petitioner are kept open.
Great. In this matter, I made the Kaveri Charitable Trust also one of the party. Then when maybe take notice.
Somebody is giving me some fees.
Learned Counsel Shri A. Ravishankar accepts notice for the second respondent. The contentions of the second respondent
please
are kept open.
Great. Okay.
36, Shankar Reddy.
Issue of Mandamus, not. It's a case, where I made a representation, not access to my property, which is situated behind the property of the fourth respondent, is trying to put up construction, without sanction, plan and license. That is my only access. Therefore, I made a representation to take steps in accordance with law.
Yes, what are instructions?
I do not take copy.
I'll put it in it. On the last date of hearing, your lordship was pleased to direct me to serve copies on the learned advocate, the other advocate, Mr. Devraj.
Somyaji appears.
On the last date of hearing, your lordship was pleased to direct me to serve copies on.
Light ಇನ್ನೊಂದು copy ಕೊಡಿ. ಇನ್ನೊಂದು copy ಕೊಡಿ. Now there is no plan.
No plan. No plan.
So they're saying there is no plan. They're saying there's no plan. Monday.
Not Monday, Thursday. Wednesday, next Wednesday. I'm looking because I'm not.
ಅಲ್ಲ ಆಯ್ತು ಬಟ್ ಅವ್ರು ಅಷ್ಟೊತ್ತಿಗೆ ಬಿಲ್ಡಿಂಗ್ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತಾರೆ.
ನಂತರ ಏನಿಲ್ಲ ಈ ಕಾಪಿ ಕೊಟ್ಟರೆ ಏನಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
This is the matter. Short date ಕೊಡಿ. 9th. Let us see on 9th.
copy ಕೊಟ್ಟಿದ್ದೀನಿ.
9th. Yes.
37, Chandrasekhar B. For respondent number 3.
Appearing for the respondent 1, 2.
Yes.
But for having complied the order of this honorable court, for furnishing memo along with acknowledgement for having deposited the amount with the BBMP.
My lord, respondent number 3, I undertaking to file a wakalat.
Counsel so and so undertakes to file wakalat for the third respondent.
Allah Bakash.
Third counsel for the petitioner to file a memo
For having complied the order of this honorable.
and submits that the interim order, condition imposed in the interim order has been satisfied.
Yes.
Memo is taken on record. The interim order
Directed me to deposit 25% of the arrears tax.
interim order passed earlier is to continue. You complete your instructions. You give a copy of the memo to the council.
I'll serve it.
Relist after 2 weeks.
Date notice.
2 weeks are date.
23rd.
Yes.
38, Raghu Prasad, yes, sir.
Notice has been served to the respondent 6 and 7 in this case, my lord. And I'm producing the online copy of the delivery notice. Kindly taken it as a notice has been served sufficient. Service of notice has been served sufficient.
6 and 7
How this one?
are they parties in the connected matter?
Yes, sir. Yes.
There is,
They are the petitioners in the connected matter.
Both have given complaint against each other.
let us see. 38.1, we'll ask him who appears for the petitioner in 3124.
Joshi.
38.1.
Raghu Prasad. Chitravati BS.
Joshi, Dattatreya Madhav.
Joshi, Dattatreya.
Now you complete your instructions.
Joshi, the connected matter 38.1 provisional order was passed. Subsequent what happened, I will just find out.
Find out. Now petitioner's matter. Now this 28103, what is the relief?
If I sought for, it is against the confirmation order passed against me to demolish my house. House construction, which is under construction. It has been initiated this proceeding in the instance of the private parties, that is respondent number 6 and 7. Therefore, by alleging that I have committed some violations and such. But this provision, these confirmation orders have been passed without conducting the joint survey in presence of me, even in spite of my specific requisition for it. And thereafter, the respondent 6 and 7, who are my neighbors, they themselves have violated and constructed their properties.
That means when you find out, you complete the instructions. Respondent BBMP to complete instructions in both the matters. List after 2 weeks. Yes.
39.
Lord, I appear for the petitioner. Lord, as undertaken, my lord, I have served the copy on the second respondent. My lord, my colleague will file the memo there. I am requesting this honorable court, my lord, to hear the matter. Is it very simple? That, my lord, the petitioner had obtained single window plan to lay a layout there in the survey number 8/2. My lord, and the single window plan was.
Just one minute. Just one minute.
I would like to file my objections.
So you appear for whom?
First respondent.
Now, who is the answering respondent?
He is seeking the relief against all the respondents.
No, who?
Earlier, it was executed in favor of the respondent number 2.
Second respondent.
Number 2 is that.
Now, my lord,
now relinquishment deed, you are seeking cancellation of the relinquishment.
Yes, my lord. Because, my lord, I have not acted upon the single window plan. and I'm not able to act upon also because of the family difficulties. Now, my lord, I am willing to sell my property, my lord, to third parties. And I have, since, my lord, I wanted to form a layout there. Since I'm not forming a layout, my lord, my which portion, my lord, 1933.52 square meter, my lord, I had relinquished, my lord, without any consideration in favor of respondent number 2. Now, my lord, respondent number 2 has been merged in respondent number 1, Bhogadi Patan Panchayat, which has to, my lord, execute the reconveyance deed in my favor, my lord.
No, now they're saying that it was only in context of the plan. Now they don't want the plan, so they're asking give it back. Needless to state, if their vendor applies, they would be bound by whatever condition for purpose of grant of plan. They are not insisting for continuance of the plan. Plan has lapsed.
Plan has lapsed, and we are not willing to continue that at all, my lord. And we will, if they cancel also, we don't have any objection.
So then you that's
Second respondent has to answer. Now I'm the first respondent.
no, correct. Now you are the authority within whom it is now vested. So you take a call now.
Then I'll get the instructions and file my objections.
Correct. I'll give you a short date.
Please.
It's simple now. You just they don't want it. You can cancel the plan. Is their stand. You take a stand. It's the stand of counsel for the petitioner that the relinquishment deed was executed pursuant to a condition imposed
in single window plan.
A grant of single layout plan.
Yes.
It is the stand that they do not seek for continuance of the said plan, nor do they intend to put up construction development in terms of the said plan, and accordingly the relinquishment deed may be cancelled and property which subject matter of relinquishment deed be reconveyed. In light of the stand of the petitioner, respondent number 1 to take its stand by the next date. List the matter in the preliminary hearing list on
2 weeks.
16. Please. Now you get oral instructions, or you get you get written instructions?
I'll make the submission.
Yes.
Serial number 40. Chandrakant Ardole.
No, 16.
For the petitioner, my lords.
My lord, your lordship, kindly permit me to appear for the petitioner.
Annexure R4, my lord. We've given an endorsement in response to the representation made by the petitioner. Saying that we have not undertaken any work. The said representation is under, they're seeking for consideration of that representation before this honorable court, my lords.
Now, have you seen annexure R4?
My lord, there is a recent development is that the chief executive officer, my lord, has made a communication to the executive officer as to whether there is any construction going on or not, for which, my lord, my learned friend may have to answer as to whether any such construction is being taken up or not. That is one aspect of the matter. Second aspect is that we have already produced substantial evidence, my lord, in documents in proof of our claim that Nada is being put up, my lord, just adjacent to in front of our house, for which they are now supposed to say.
So Tumkur Mahanagara Palike has taken the stand that they are not.
That is wrong. That is the first and third respondent. 1 to 3 respondents may have to say something in the matter, because these people are colluding with each other to say that we are not constructing. Respondents 1 to 3 were to say.
Respondent number 4 has to answer. They have stated before the court, stating that they have not put any knowledge or.
No, correct. Now you also clarify.
Yes.
Public Works Department.
Yes.
Whether this comes within a jurisdiction. Find out. Let us. The stand of respondent number 4 is as evidenced by annexure R4 to the statement of objections filed. It is submitted that the respondent number 4 has not taken up any project of laying out a drain in the property of the petitioner. The other respondents to take stand regarding the assertion of the petitioner, if any, by the next date. Relist the matter on after 2 weeks. Date after 23rd. List the matter in the same stage. Yes.
Interim order. Interim order is only against respondent number 4, my lord.
Interim, whatever interim order is there, may kindly be extended, my lord.
Status quo to be maintained regarding the property. Status quo to be maintained regarding the petitioner's property as on date.
Much.
Let us. Yes.
41. Cell number 41.
Respondent 3 and 4, Your Lordship.
Yes.
I for the respondent 3 and 4.
Yes.
Siddhavir. 41.
Now you complete the instructions.
Let's.
Yes.
I beg to appear for the petitioner in this case, my lord. I filed the application for impleading the proposed respondent, my lord. The proposed respondents are the respondent number 5 and 6 are my vendor's daughter, my lord. And the respondent number 7 is the tenant under 7 and 8 are the tenants, my lord, who are allegedly said to be in occupation of my premises. My lord, this writ petition I have filed for seeking a writ of mandamus to the respondents to effect khata in my name and subsequently grant me permission to demolish the construction. And the other prayer is, my lord, insofar as other respondents, DESCOM is concerned.
You take out
please,
notice on your IA. Office
please,
objections raised on the said IA to be rectified. Upon clearance of office objection, issue notice on IA 1 of 25. List after 2 weeks. Yes.
42.
Gratefully.
42.
For the petitioner.
Yes.
Respondent 4.
Last date.
After issuance of Millard Shoka's notice, the respondent 4 Millard has approached BBMP and they have given some documents. They had to give another documents they have given. Therefore, the final notice not issued, Millard. 248(1) and Shoka's notice and provisional order passed, Millard.
No, what about construction?
Construction is stopped and there is no construction. Construction almost 4 floors, Millard, is 1 floor is a deviation is there that was completed. There is no construction activity.
Deviation is completed.
Not construction work is earlier completed, Millard, and no construction going on spot because of the filing of this petition after issuance of notice.
My lord may kindly see the petition.
when I filed this representation on 15/7/2024, still the building was not complete. BBMP does not take any action. I have produced, kindly see annexure A, page 12, my lord. This is how the building was. My lord, now, if your lordship sees the notice that is issued by BBMP, they have produced the photographs. They have completed the construction. My lord, now what they are trying to do is, they are trying to sell all these apartments. In fact, I am told that there is more than one house even on each floor. Almost 10 houses are there on a 40-60 site.
Now, is there a plan or no plan?
Plan is there, only the construction is one floor, fourth floor is totally deviated and front portion deviation is there. That is the provisional order shows.
The
Silt plus 3 floors plus terrace floor is the permission given. Fourth floor is constructed. It is, we undertake, my lord, we will not sell the fourth floor. And the remaining things, my lord, is we are submitting the document before the authority and they have to take appropriate order, my lord, now. In view of, we are submitting some documents.
No, now you don't create any third-party rights.
Third-party rights in so far deviation portion after fourth floor, we will not do.
No, what about setback? That is also deviated portion.
Yes.
Setback 100% on the front side. You don't create third-party rights, we'll see.
Very well.
Millard, before that, Millard, some agreements entered, Millard. That's why, Millard, some pressure is there.
That I don't know. Now
Yes,
that
Millard.
you make them parties, let them also know about the building. In one matter today, they have sold away the.
Not registered any.
Correct, I'll tell you.
As per instruction, not registered any
Correct.
document.
So in one matter today,
Yes,
the building owner without plan has sold the property with 3 floors or 4 floors. And then the notice was issued to the occupants. They have taken loan and purchased the apartments. Meanwhile, it has come to their knowledge that there is no plan.
In this
So
matter,
third-party rights will be prejudiced unless you clear all the defects at this stage only.
Millard, only one my submission I make, Millard, for that. Millard, I had to file appeal before unless and until issuing final notice, Millard, I can't file appeal before the chief commissioner.
Correct.
In the meantime, what happened, Millard, petitioner 2 to 4 are the advocates, Millard, as personally they have no locus standi, they are not the adjacent owners and neighbors of the property. They are 2 to 4 may kindly look at in the cause list, Millard. They are not adjacent owners either of the building, 3 sites. They are nothing to do with this property. And for kindly similar,
Now,
2 petitioner 2 is nothing not resided in that area. 3.
Just 1 minute. Now your neighbors or what is it?
Neighbors, my lord. Neighbors. In fact, the first petitioner is immediate neighbor. The second, third and the fourth petitioners are all residing in the fifth petitioners are all residing in the same road. My lord, this building can house only, even according to the plan, one floor can have only one house. There are about 10 houses, my lord. Parking will be a problem. There will be a problem for the drainage system. Water will be a problem.
There are 4th B cross residing. Property is 4th B main. And they are nothing to do with the petitioner 2 to 4. 4th B cross is far away from the property.
Okay.
No, they are all affected, my lord. They are all affected.
No, 1 minute. Petitioner number 1 is your neighbor.
Millard, petitioner number 1 is also Millard as per the Millard. There is no obstructions from the petitioner 1 also, Millard.
Petitioner number 1 is your neighbor.
He is a neighbor. And others, Millard, is only joined together and filed. Raising petitioner 1.
That will see. They are only joining the first petition. Now you don't create third-party rights. You go and try and sort out all the deviation. We'll see.
Millard, that order, Millard, will create, Millard.
No, but that's what the Supreme Court has held.
Yes, Millard. Millard, we see, after issuance of legal notice, Millard, statutory notice, we are giving reply. In the meantime, Millard, either they have to issue final notice or I have to liberty has to challenge that. And nothing is there, Millard. In the meantime, this order, Millard, is passed. We invested huge cost, Millard. We undertake that we will not sell the 4th floor totally.
No, you undertake yes, that you will clear the deviation.
And we will pursue that, Millard, and take appropriate remedies, Millard, to
what my, once the
You look at,
248,
you look at 21.1. Pawan Kumar, you read it. Read it. This is what Supreme Court has held. You read, Pawan Kumar. Read it aloud.
Para 21.1. While issuing the building planning permission and undertaking be obtained from the builder or applicant as the case may be, to the effect that the possession of the building will be entrusted and or handed over to the owners or beneficiary only after obtaining completion and occupancy certificate from the authority concerned. Point 2. The builder or developer owner shall cause to be displayed at the construction site a copy of the approved plan during the entire period of construction, and the authorities concerned shall inspect the premises periodically and maintain a record of such inspection in their official records. Third point, upon conducting personal inspection and being satisfied that the building is constructed in accordance with the building planning permission given and there is no deviation in such construction in any manner, the completion occupation certificate in respect of the residential or commercial building be issued by the authority concerned to the parties concerned without causing any undue delay. If any deviation is noticed, action must be taken in accordance with the Act, and the process of issuance of completion occupation certificate should be deferred unless and until the deviations are pointed out and are completely rectified. Point 4. All the necessary services connection such as electricity, water supply, sewerage connection, etc. shall be given by the service provider board to the buildings only after the production of completion and occupation certificate. Point 5. Even after issuance of completion certificate, deviation violation, if any, contrary to the planning permission brought to the notice of the authority, immediate steps be taken by the said authority concerned in accordance with law against the builder, owner, occupant, and the official who is responsible for the issuance of wrongful completion occupation certificate shall be proceeded departmentally forthwith. Point 6. No permission or license to conduct any business or trade must be given by the authority, including local body of states or union territories, in any unauthorized building, irrespective of it being residential or commercial building. Point 7. The development must be in conformity with the zonal plan and usage. Any modification to such zonal plan and usage must be taken by strictly following the rules in place and in consideration of the larger public interest and the impact on the environment. Point 8. Whenever any request is made by the respective authority under the planning department or local body for cooperation from another department to take action against any unauthorized construction, the latter shall render immediate assistance and cooperation, and any delay or dereliction would be viewed seriously. The states and UT must also take disciplinary action against the erring officials once it is brought to their knowledge. Point 9. In the event of any application, appeal, revision being filed by the owner or builder against the non-issuance of completion certificate of a regularization of unauthorized construction or rectification of deviation, etc., the same shall be disposed of by the authority concerned, including the pending appeals, revision as expeditiously as possible, in any event not later than 90 days as statutorily provided. Point 10. If the authorities strictly adhere to the earlier directions issued by this court and those being passed today, they would have deterrent effect, and the quantum of litigation before the tribunal courts relating to the house or building construction would come down drastically. Hence, necessary instructions should be issued to all the state and UT governments in the form of circular to all the concerned with a warning that all directions must be scrupulously followed, and failure to do so will be viewed seriously with departmental action against being initiated against the erring official as per the law. Point 11. Banks and financial institutions shall sanction loan against any building as security only after verifying the completion and occupation certificate issued to a building on production of the same by the parties concerned. Point 12. The violation of any of the direction would lead to initiation of contempt proceeding in addition to the prosecution under the respect.
So now, in terms of that that stipulation, which says that amenities will not be provided till it is solved, no amenities to be provided. Let it be solved till this issue is settled. No amenities to be given.
My lord, what happens is if they execute one more aspect, my lord, what happens if they execute sale deeds? They will be necessarily, they will have to put them in possession and they will come and start living there. Then they will plead equity. All these issues will arise.
We'll give instructions.
Yes.
Till they solve it, no amenities.
Very, very well.
in so far petitioners 2 to 4 Millard is concerned,
That we'll see, that we'll see. The respondent BBMP, counsel for respondent BBMP submits that 248(3) order is yet to be passed.
They have not filed any reply to provisional order.
As
Last time they have
reply
undertaken.
under 248(2) to the provisional order is still to be made by the petitioner.
Respondent.
By the respondent
Respondents
number
4 and 5.
4. The interregnum. Taking note of the allegations made by the petitioner and noticing that construction is still to be completed. If construction is completed or
The
what?
construction full or completed, my lord, only interior work is pending, my lord, except that nothing construction part, nothing, my lord.
And noticing the stand of the petitioner that construction is completed, while also noticing the photograph at annexure A, which would reveal construction at the initial stage when the petition was filed. It would be appropriate.
This is a old dated, my lord, back to.
It would be appropriate to restrain granting of amenities by the Water Supply Board and the Electricity Supply Authority till the issue is of 248 proceedings is resolved. Such order is passed taking note of the directions of the Apex Court in Civil Appeal 14604 of 2024. Full stop. This interim order is subject to modification upon conclusion of the 248 proceedings. List. After
Meanwhile, let them also not alienate the fifth floor, my lord. That's if they create any charge in so far as that. Admittedly, they say that it is a deviation.
So far as the
Fourth floor only, my lord, not fifth floor.
Fourth floor.
No,
so far as
5
the
floors.
fourth floor is concerned, it is the stand of the private respondent that fourth floor is admittedly unauthorized. If that were to be so, no third party rights to be created by respondent number 4 insofar as the fourth floor.
Yes.
Let them file a reply.
Lord,
my lords.
we are
Let them
giving,
file a
my lord,
reply,
we
otherwise
went into,
confirmation order will be issued. Let them file a reply. Last time they have undertaken.
Needless to state, respondent number 4 to file their reply to the 248(2) notice within a period of 10 days from today.
Lord, liberty may be to subject to production and subject to passing of 342.
The respondent is at liberty to seek for modification of the order after final order is passed under 248. Yes.
43, serial number 43, Purna Chandra M.
Last date of hearing, notice was issued to respondent number 4. No one has entered appearance for respondent number 4. And summons was also issued.
Yes.
This is for the private.
So who's the answering respondent?
Respondent number 5 is the person who is constructing.
No,
Respondent
but
number,
who's the authority to take action?
respondent number 4, my lords. Town panchayat.
Panchayat.
Is Bopanna, who's there for Baindur Town Chief Officer by Baindur Town
It is a
Panchayat?
newly,
Huh?
it's a newly formed town.
Well, somebody must come there.
It is served recently, I think, my lord, it is served some days back, because last hearing date, my lord, notice was issued. He has taken fresh steps, my lord.
What is the matter now?
Lord, the matter was earlier there was construction in the no construction zone, which says that from the district main road 25 meters has to be left. But during the pendency of this writ petition, a subsequent notification was passed which says the 6 meters has to be left, and now they are safe in that aspect. But there are setback violation in respect of southern and western portions of the scheduled property.
No,
And
no.
the san,
Now, Bopanna, just find out who.
Last hearing date, I have produced the, my lord,
yes, produce a new notification.
No, that we'll see. Now, we need the fourth respondent to come on record.
Yes, my lords.
Ah.
I was also directed to file the status of construction. I'm filing it along with the memo.
Now, the petitioner files memo along with the report regarding stage of construction.
The ground floor has been constructed.
Now you find out who appears for that authority.
Yes, please, my lord. In the meanwhile, I will also find out.
Relist the matter. Now, if you have the phone number, you give it to him.
Yes, my lord.
Fourth respondent, you gave the contact numbers to the government advocate, he will call and he will.
Yes,
instruct. Relist the matter in the orders list on
Dot date.
9th.
Please.
Grateful.
You give whatever contact numbers to the government advocate, he will contact.
Grateful.
44. Somayaji.
Petition.
R5 notice served respondent.
Office to put up report regarding notice issued to R5. Relist week after next.
45. Serial number 45. Inter-Priyadarshi Prasad.
For the petitioners, my lord.
Lord, this matter pertaining to my lord, 76 O notice has been issued, my lord. So, my lord, suspension of the layout, my lord. The main contention is, my lord, notice has not issued.
No, correct. Now, so you take your stand now.
My lord, I have taken instructions, my lord, that this notice is treated as, my lord, show cause notice, my lord. Let them give all representation to the authority, my lord. We consider and pass an approved order.
My lord, Annexure A, page number 42, my lord. Your lordship may kindly see. It cannot be treated as a show cause notice.
No, now we'll treat it now.
Please.
Now, whatever, we will say that this will be treated as a show cause notice. They will not, they will hear you, and without hearing you, they will not pass any order.
Please.
All
Meanwhile, my
contention-
lord, Annexure A may be kindly be set aside, my lord.
No, we will direct it to be treated as a show cause notice.
Please, my lord.
Any action
My lord,
taken,
please,
action taken hitherto will be expunged.
Yes, my lord.
And then it will start afresh.
My lord, my humble submission is, my lord, there are 291 sites in the present layout, my lord. The writ petitioners are only 22 owners. My lord, 117 sites have been released. I don't know the remaining parties also, my lord. As of now, only 22 site owners are before this honorable court.
Lord, kindly see, my lord.
Now they are recalling the entire sanction plan.
Yes, my lord, entire 291 sites have been
You will
suspended.
have to issue notice to all concerned.
Please, my lord. We have issues, my lord, because of, my lord, in the reference, my lord. One Uday Kumar has given a complaint, my lord, regarding, my lord, reference number 4, my lord, kindly see, my lord. In that regard, my lord, we have issued notice to the, my lord, developer not, my lord, come before us, my lord, and not say anything. That is the reason, my lord. Now, my lord, we have considered all my lord, grievance by the, my lord, petitioner itself. And also, my lord, we take steps to whether, my lord, third party right is created or not. And if they are created, my lord, we will consider and pass an appropriate.
Now you have to issue notice to all affected parties.
Please.
My lord, page number 48 is the release order, my lord. 48 of the writ petition. ಅದರಲ್ಲಿದೆ ನೋಡಿ ಸ್ವಾಮಿ ಮೇಲ್ಕಂಡ ನಿವೇಶನಗಳನ್ನು ಗುರುತಿಸುವ ನಕ್ಷೆಯ ಪ್ರತಿ ಒಟ್ಟು my lord 116 sites have been released.
Anyhow, you issue notice to all and then you see.
Please,
my lord, our, my lord, endorsement itself says that, my lord, one Uday Kumar and Vasudev, Shobha Vasudev also given OS filed, my lord, and regarding the occupation.
Correct. With respect to the and sanction before 2014,
please, my lord.
Whether at this moment you can
my lord.
initiate action is also something you have to look into.
Initially, my lord, one Venkatesh Rulu filed the writ petition before this honorable court. After, my lord, hearing this honorable court directed to, my lord, to both parties, those are aggrieved and, my lord, developer, go before the settlement and, my lord, submit to the authority. They didn't come, my lord, before the authority. That is the reason, my lord, we have issued notice. Anyhow, my lord, we have not issued, my lord, petitioner is concerned. Now, my lord, it's treated as a show cause notice, my lord, I will consider and pass on.
But you will have to also look into whether for a plan
please
issued on 16/12/2014,
please, my lord.
whether you can take steps at this point of time.
Regarding, my lord, regarding 76O is very clearly say that, my lord.
Huh?
76O of the ATCP Act, my lord.
Huh.
They clearly say that, my lord, any mischief and order passed, my lord, to.
No, my lord, it is on the ground of misrepresentation and fraud. My lord, if it is a fraud, then they have to demonstrate as to how the fraud is committed upon the planning authority.
76?
O, my lord.
76, oh my lord.
Capital O.
Now you reconsider it at your end. Let him, you hear them.
Please.
Even
Attest.
before you
Please,
issue
please.
notice, you hear them.
Please.
And
Them issue
take a
notices
call.
to the, all the concerned parties, my lord, and we will appear and we will file a representation to the planning authority, my lord.
So regarding, my lord, those who are, my lord, affected, my lord, they let them give application, my lord, we will consider it. Anyhow, my lord, it is considered as a show cause notice and 76 capital O, my lord.
After they give the reply, you can also take a call whether you need to continue or not.
Please, please, my lord, as accords with law, my lord.
The petitioner, the petitioners who are site owners, numbering 21. They have called in question the validity of the order dated 17/2/2023, passed by respondent number 3, suspending the sanction
Plan.
for development
Plan.
made on 16/12/2014 as per annexure A,
Annexure B, my lord, B and C,
as per annexure B and C.
B and C.
B and C. Full stop. It is the case of the petitioner that the order passed at annexure A cancelling the plan, suspending the plan, is without notice to the petitioners who have purchased sites in the layout plan approved by the authority. Full stop. He submitted that admittedly the layout plan was approved in the year 2014. An exercise of power is after an unreasonable period of time. Various other contentions have been raised. Full stop. It is a case put forward by the petitioners that there is no power under 76O for temporary suspension of the plan. It is next. Learned counsel for the respondent, planning authority submits that the order at annexure A may be treated as a show cause notice, and the planning authority may be permitted to proceed afresh by treating the order at annexure A as a show cause notice. No, but then this is an order of suspension.
Please, my lord.
We can give you liberty to pass
Please.
fresh notice. Next, noticing that the order at annexure A affects civil rights of the petitioners as they are purchasers of sites. Clearly, no order could have been passed as at annexure A without hearing the petitioners. Accordingly, the order at annexure A is set aside, reserving liberty to the respondent to take action in accordance with, strictly in accordance with the safeguards for the property holders in terms of proviso to 76O of the Town and Country Planning Act. While taking fresh steps, respondent authority may grant an opportunity of hearing to the petitioners. And consider preliminary submissions before deciding whether notice under 76O is itself warranted. All contentions of the petitioners are kept open. In the event, kept open. We leave it at that. You first go and you
Please,
your submissions, let them decide.
Please, please.
as per my instruction, my lord, only 116 sites has been released, my lord. Other sites has not released. Here, my lord, the developer has, my lord, without, my lord, permission of the authority, my lord. Unreleased sites also, my lord.
So now you hear them and then you take a
Please.
call.
46, sir. Manjunath, yes, sir. Devaraj,
Would I receive the wakalat malas? For the
Next
petition
week,
malas.
Yes.
ಅಲ್ಲ ಇದರಲ್ಲಿ
I do not have copy of it.
next week would I receive the wakalat malas?
Relist same stage on date.
22.
Yes.
47, Rajesh Rupian.
Filed wakalat for respondent number 2 and 3, my lord, in this today. My lord, this is disqualification proceedings under Defection Act. They are, my lord.
Correct. So what we were intending to do is instead of keeping it pending, we send it back on the undertaking that he will not take any adjournment. And
What they have sought for is 7 days time, my lord. They have filed an application. They have been given two times opportunity to cross-examine. They have not done so. On 5th, my lord, they have filed an application for seeking 7 days time. That has been rejected and the matter was reserved. Now, as per your instruction, oral instructions, my lord, orders are not at passed. Lordships may grant them 7 days time which they have sought for. And my lord, direct the deputy commissioner to complete the proceeding because
now
under
correct. What is the stage now?
it is reserved for orders. Orders have not been passed because your lordships have
Correct. So now
directed.
Correct. So to what stage it has to be remanded now?
My lord, for cross-examination.
Cross-examination, my lord.
Cross-examination.
And also for argument of the appellant, my lord. For the petitioner, my lord.
So it will start from the stage of cross-examination of the respondents.
Complainants.
Complainants.
If they want to lead any evidence, my lord, they are left to it. But entire proceedings should be completed within 7 days. For this reason, my lord, the proceedings under the act, my lord, the time frame is for 60 days. Now it has been almost 90 days is lapsed. It has been 5 months, my lord.
No, correct. So how much time?
Yes.
We'll record that. How much time the whole proceeding?
7 to 10 days.
The whole thing you'll complete.
My lord.
But it will begin with the stage of cross-examination.
Cross-examination. And then we will say that on whatever date is fixed by you, they will not take any adjournment.
Yes,
please.
That should be.
Day-to-day basis we will conduct.
That is up to you. I'll record that submission.
And with the direction to cooperate the
Please.
other parties to cooperate.
The-
This is that goes on making applications.
No, the main purpose is to
Drag
the matter, my lord. Because
with a strict instructions to the parties to cooperate with the procedure.
He successfully dragged it for 10 days.
Yes.
The petitioners have sought for setting aside of the order dated 5/3/2025 at annexure A.
Page number 20, my lord.
4/3 or 5/3?
Page number 20, my lord. ಇದು ಪೇಜ್ ಸ್ವಲ್ಪ ಹಿಂದೆ ಮುಂದೆ ಆಗ್ಬಿಟ್ಟಿದೆ.
3/2025, whereby the stage of the case which was set out for cross-examination of the complainant was closed and matter was reserved for orders.
yes,
Please.
Full stop. Various contentions have been raised by the petitioner to the effect that no sufficient opportunity was granted. Next. After hearing the matter for some time, it is found appropriate to remit the matter back to the Deputy Commissioner to proceed with the proceedings from the stage of cross-examination of the
From
complainant.
complainants.
Full stop. Learned counsel for the petitioner submits that they would not seek for any adjournments if opportunity is granted. Full stop. Taking note of the necessity of concluding such proceedings within a time frame. There's a time limit, is it?
There is already 60 days.
Under
Yes,
the
my
act.
lord. Under the act,
My
it
lord.
is 60 days.
My lord,
60 days.
Section,
Section 4, my lord.
one
Not wrong, my lord,
one
it is section
clarification,
4.
my lord. The opposite party is the petitioners here in my lord. We have to cross-examine to the complainant.
correct. Taking note of the time frame as stipulated under section so and so.
My lord.
It is necessary that the proceedings are to be concluded by the deputy commissioner without any unnecessary delay. Full stop. Accordingly, the order dated 5th March 2025, the set aside proceedings are restored to the stage of cross-examination of the complainant
Complainant.
Please.
by the petitioners herein. After such cross-examination, petitioner is not to take any adjournment on the date fixed by the deputy commissioner and cooperate in expeditious disposal of the proceedings. The undertaking of the petitioner to cooperate in expeditious disposal of the proceedings is taken note of. Accordingly, the petition is disposed of in light of the observations as made above.
Please.
The lordships may say
7,
7 to
particularly let them up.
Third council
The date, no?
10 days.
petitioners to be to mark their presence before the deputy commissioner on
Friday, my lord.
no, your party must be there.
We will be presenting.
Monday, my lord. The certificate copy ಬರ್ಬೇಕು.
Yes, my lord. 7th we will appear.
Monday. On 7th at
3
3
p.m.
p.m.
3 p.m.
Please.
The submission of Land Council
Within 7
appearing for the
working days, we
state
will come.
that proceedings will be taken on day-to-day basis subject to availability of the DC is taken on record.
7 working days.
And it is also submitted that the DC will endeavor to conclude the proceedings within 7 days.
My lord, ಅಲ್ಲ argument
7 working
my lord 15 days ಅಂತ ಹಾಕಿ. My lord, because argument ಆಗಬೇಕು 15 days ಅಂತ ಹಾಕಿ.
7 working days is taken on record. Needless to state, the DC may assign necessary dates and petitioner not to take any unnecessary adjournments.
Please.
Not section 4 subclause 2.
Section 4 subclause 2.
Time frame is.
Yes.
48.
Proceedings,
respondent number 1,
petition is disposed of without awaiting. Now, you appear for all the respondents.
2 and 3, my lord.
2 and
One,
3.
One government.
Those only 2 and 3 other parties.
Yes.
For 2 and yes.
Lord, I appear for R1, my lords. We have received the copy today only, my lords. Kindly have it day after tomorrow, my lords.
Relist the matter on date could be shorted.
9th.
Yes.
Mobilize.
Please. 49. KBFIR.
Weeks time granted to take
Lords, we have
necessary.
taken steps, my lords. BBMP was directed to produce the sanction plan on last day.
The 313 notice has been issued. They have fixed the date of inspection of 4th, my lordship. Kindly have it next week, any date. I will file the report.
Weeks time granted. Learned counsel or petitioner submits, necessary steps are taken. Office to verify and issue notice to R4. Meanwhile, respondent BBMP to take their stand after inspection. Relist the matter on 4th Admiral date.
My lords, next week any date, my lords. There is a application for stay, my lords.
9th.
Please, my lords.
Yes.
Much of.
Hearing again, 50 urgent, 51, semi-rescent. 51,
50 for respondent.
They moved at 10:30.
I have not been informed. Respondent. Unfortunate. ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್? ಸಾಹೇಬ್ ಡೇಟ್ ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಯಾಕಂತಂದ್ರೆ ಇಟ್ ಇಸ್ ಅ ಮ್ಯಾಟರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. They have not challenged the survey conducted by the authorities concerned, and they have come before the resolution passed by the Gram Panchayat. Land belongs to the Gram Panchayat. They wanted to take one reason, other reason, adjournment. The entire area is allotted to scheduled castes, scheduled tribes for residential purpose. So that what I am submitting you are also, one short date may be fixed.
ಯಾವ date? 16th.
Much of it.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು 10:30 ಕೇಳ್ತೀನಿ, ಕೇಳಿದ್ದೀರಾ ಅಂತ. ನಿಮ್ ಫ್ರೆಂಡ್ಸ್
ಹೇಳಿಲ್ಲ, ಹೇಳಿ ಸಾರಿ ಇವರ ನಮ್ಗೆ ಹೇಳಿ ಅದಕ್ಕೋಸ್ಕರ
ಕರೆಕ್ಟ್ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ,
ಅದ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಸಾರಿ.
Yes.
Lordship, I am for proposed R4, my lordship. Praise 1 week time, my lordship. Seeks adjournment for a week time, my lordship.
We'll refix it. Relist the matter on
Date may be fixed.
23rd.
23rd.
Much.
Interim order, my kindly fix.
Interim order in operation extended till the next day.
52, Sagar.
Becomes infectious, my lord, because
Petitioner, my lord.
Lord,
Yes.
the main grievance was that, my lord, there's an arch which was set up, built, my lord. Now the arch itself is demolished. But if they are okay, my lord, then it is.
Thanks for 1 week accommodation, my lord. Senior is unwell, my lord.
No, now you had sought for.
My lord, they are yet to produce the photographs, my
I have already produced, my lord. 11 June 24, I have already produced.
Received the
Verify
copies.
now. If the arch is not there, now what survives now?
We haven't received the copies, my lord.
Relist the matter in preliminary hearing list, short date. I have handled this matter earlier.
Yes, my lord.
This is the arch matter which my lords are
Arch
directed.
matter. 4th.
Lords are directed to demolition, my lord. That is on
Correct.
the- yes.
In preliminary hearing list.
Much.
Yes.
53,
Petitioner in this case. Respondent Miller's lordship. 1 week short accommodation will be granted in this matter, Miller's.
Previous, your lordship, what has happened? R4 was arrived as a party. In the meanwhile, they being aware of the present petition filed before this honorable court, they have gifted the property in her daughter's name. I have filed the application to arrive the fresh respondent as and she has been served.
Served.
And this honorable court on the previous occasion suggested that it will be taken up the matter in entirety.
So we'll allow the impleading application. We'll allow the impleading application.
It is my application.
So we'll allow that now.
Kindly, Your Lordship.
The impleading applicant, though served, no, some counsel appears, is it? DB Venkatesh. Is it done at 53? 53 then. DB Venkatesh for R4. It is noticed that IA 1 of 24 was filed to implead the impleading applicant to whom the 4th respondent has gifted the property.
Yes, in favor of her daughter,
Ye Kavita Miller.
Suman.
It is submitted that the proposed respondent, the proposed respondent is the daughter of the 4th respondent.
Howdu.
And had executed a gift deed on 3/7/24.
Howdu.
During the pendency of the
Present petition, Your Lordship.
On 3/7/2020, 3/7/2024. Though served, no representation for the impleading applicant. In light of the case made out, the application is allowed cause title to be amended. What is the main matter now?
Your Lordship, what has happened, Your Lordship? I have a site. It is at page number 4, Your Lordship may kindly look into it. Facts of the case. It is of 2,850 square feet. Your Lordship, my name is mutated.
Now you amend it, we'll have it tomorrow.
For me?
So that let the name of the amendment to be carried out, list the matter in the orders list tomorrow. No representation for R4. Yes.
My lords, one submission, my lords. Serial number 52, my lords.
Serial number
Interim order may be.
Just one.
Serial number 1 in list number 2. There's some problem with it. So actually it is a premature petition because we have just sent the list to the planning authority and they have to take a call. And the person who has now been recommended has not been made a party. And apart from that, there's an alternate remedy also 309. All these are there. So the stay which has been granted may be kept in abeyance and posted for being spoken to. Because of the glitch, I could not.
You file a memo. You file a memo.
Yes. I'll file.
At the post.
Serial number 10, come as serial number 10 in the first list. Come as some inconvenience. Kindly have it PC. Become only one serial counsel is not some inconvenience. And briefly, my lord, kindly have it on Monday.
Just inform the other side.
Serial number 10 in the first list.
Inform the other side and report to the court office.
Serial number 52, my lords. My lords, there is an interim order, my lords. Kindly be extended, my lords.
Serial number?
52, my lords.
Serial number 59, so pronouncement of judge.
Pronouncement of order, serial number 59. Pronouncement of order, serial number 59.
Responded.
For the petitioner. 15 and 130.
Second is, can I pray for a person?
WP 15015. I have rejected. The other petition I have disposed of. It will be uploaded by today.
Kindly, my lord, list 2, serial number 18, my lord. Please, my lord.
230, mentioning at 230.
Serial number 18.
The one memo. Kotte sir, kotte.
Serial number 18, second list. Abhinay Usharilla.
ಒಂದು ನಿಮಿಷ ಇಲ್ಲಿ ಫಸ್ಟ್ ಇದು ಯಾವ್ದು ಗೊತ್ತಾ? Petition 9522 of 25.
List 2. You inform the other side. At request, relist the matter. 1/6. 1/6. You appear for? At request, this 25655. At request, relist the matter. Yes. Huh?
12.
Good.
16th.
Inter-modern operation is extended till the next date. 26 of list. Which list? You appear for the. Have you informed the other side? You have informed. At request, list after 2 weeks. Bangalore Urban, PDO Bangalore Urban, Gopanna. Bangalore Urban. ನೀವು ತಗೊಂತೀರಾ? Land Council DJ Somyaji accepts notice for R1. List week after next. Serve a copy. Serve a copy.
Serial number 1, Chandrasekhar KN. Pattegowda.
List no representation on behalf of the petitioner. List week after next. Yes.
Serial number 3, N. Ramakrishna. Somayan.
Now the inquiry is still in progress. Inquiry is still in progress. Then how do you stop that inquiry? No, anyhow, I'm not granting an interim prayer, but you complete your instructions. 3 and 4. Learned counsel, DJ Somyaji undertakes to file wakalat for respondent. 3 and 4. What about 2? Chief Executive Officer, Zilla Panchayat, Bangalore Rural District. Learned Counsel, Sri M.S. Devraj appears for the second respondent. 3 and 4, B.J. Somyaji. Relist the matter. Date kodi. After 10 days, you complete the instructions. Copies kodi. Relist in the orders list on.
21st. Serial number 10. Serial number 10. Demantika Gowda. Serial number 10. Demantika Gowda. Suresh Babu. Serial number 10. Demantika Gowda.
Correct. Correct. Yes. Relist on 9th.
Serial number 22. Nishant AB. 22. Nishant. Vivekananda TP.
Password.
24. Serial number 24. Lakshmi.
Learned Counsel N. Praveen Kumar is directed to accept notice. Relist the matter on date code. 21st. Yes.
List 2, serial number 2. Hirapagoda, Hirapreddy M. D. Nagaraj.
Now, what is the matter? Auction has taken place. Not except in accordance with law.
Next to 54.
That we'll see. If you want, you can participate without. You have right of first refusal also. The petitioner has challenged the auction notification on various grounds. But, noticing that the auction proceedings are to be carried out in terms of the government order dated 19/7/2019. Government order 19/7/2019. It is clear that the petitioner cannot be dispossessed except in accordance with law. It is open to the petitioner to participate in the auction proceedings if so advised, without prejudice to the contentions raised. The right of first refusal, as per the government order dated 19/7/2019, would be available. List a week after next. Learned Counsel so and so appears on behalf of the respondent. Needless to state, the auction proceedings would be subject to outcome of the present petition.
54, serial number 54, continuation. 54, Ladit P. KV Narasimhan, AGA.
Yes. Five 12. Yes, yes. Huh? No, pass over. Pass over. No, no, he's passed. Huh? No, but according to normal practice, even in our administrative functions, we don't enter into a contract till the funds are, still there's a budgetary provision by the state. Normally, even in the High Court, if you, where we enter into any contract, we don't enter until a budgetary provision is made. After entering into the contract, you can't go searching for funds. Correct. But what I'm saying, if a work order is issued, normally, even for our court buildings, they don't issue tender, PWD, unless there's a budgetary provision. It's only deferred. So once the work order is issued, that means budgetary provision is already made. So where is that money gone? You will have to check whether you have, no, that budgetary provision will be made for that. Yes, then what? Has? Correct. So then you find out. I'll have it on Monday. You find out and make your submission.
Two aspects. I just point out. They're trying to put the blame on each other, but two aspects. One is the corporation has the funds. To Right to Information Act, we wanted to know whether the corporation has funds. They have funds through FIR, which they have collected, and they've used that funds even when it came to payment of certain salaries, not pertaining to the FIR, but for something else, but the funds are used. Secondly, when it comes to the government, for the very same scheme, government had given passed an order to the municipality to release 19 crores to another contractor. Either way, whether it is going to be the state government or whether it is going to be the corporation, corporation has funds or state government can direct them to pay the amount. After having done 80% of the work, 9 crores due, a contractor becomes extremely tough for it to even survive like this. And they say it's an admitted third party certification, everything done, and under the contract, every 60 days they're supposed to make payment. I'm supposed to give their bills every month. Every 60 days they're supposed to make payment.
Yes.
Either way, I have documents for both owners. I have documents to show they have funds. I have documents to show state government has directed in one of the matters asking them to pay 19 crores to the contract. And the previous order passed us 4 months back. Despite that, we're not in a position to.
Both of you make joint submission on 9th. Whatever you sort it out amongst yourself. If you have issued it, you place it on record that we have allocated budgetary provision for this work. You state, and then you ask them to release. If you have not given, it's you work it out amongst yourself.
One more aspect is this is scheme one under which they gave this total amount in scheme one was 125 crores. Now, my lords, they come up with scheme two, phase two of the very same project, my lords. Total allocation is about 165 crores. So scheme one itself, they're not able to make payment
there must be some financial closure also. Within 6 months or whatever you have to close. I'll have it on 9th, you work it out amongst yourself. Both the respondents to take a joint stand regarding admitted dues of the petitioner by the next date. Relist the matter on 9th in the same stage.
55. V.B. Shivakumar.
At request, relist the matter week after next date.
56.
Yes.
Vaishali.
In this matter, my lords, your lordships had passed an order directing an inspection to be done in our presence.
That is done. That is done.
Done, and they have given a report. It's of course served on us. Same thing. Served on the party. Court. Court gets. My lords, I have seen, my lords, the report is given. If my learned friend hands over at least corporation, you can. That's what they find in the front side, my lords. They find, my lords, certain violation of balcony, which we have said the lordships have that report, my lords.
Yes.
That front, it starts with front south side, if your lordship sees. Building owner present at site agreed to remove the projected balcony of 0.40 meter from east to 1.40 meter at west. But the setback as per sanction plan is 3 meters, 2 columns, one at east and another at west. Beam and solid block masonry wall constructed above has to be removed to bring the setback to sanction limit. Now that, my lords, if I remove the beam and the whole building structure only will fall. The other back side also, my lords, that if your lordship keeps the provisional order in hand at annexure B1 for a moment, because they have not given the measurements.
The final order is passed.
Final order was passed. It was our case that they were not without any notice to us, and the appeal also came to be dismissed, which we have challenged. But your lordship said an inspection can be done if anything can be worked out.
So far as notice now, if you verify from your records regarding service of notice, if there is some doubt, then it will have to be relegated back for fresh consideration.
Because all these sajjas, my lords, the owner, they have recorded, we have said we will remove whatever is the, but the pillar is the only issue, my lord. Pillar and beam, if I remove, the entire structure only will fall.
So you now examine regarding notice. It has to go back, let it go back. Respondent BBMP to place before a court a Xerox copy of the entirety of proceedings under 248. In the case of the senior counsel appearing for the petitioner, that there was no notice in the
served on
the petitioner as regards proceedings under 248. Would be stay of
demolition stay ಮಾಡಿದ್ರು.
Earlier granted is extended. This is the matter week after next in B group.
Lord, sir, a little earlier, because my entire construction I have stopped. The employees, everybody, construction material also is lying there.
Now you just check on the notice, sir. If there is any defect in the notice not having served, then we will ask them to present before you, and you will reserve liberty for you to redo the procedure. Release the matter on
23rd.
23rd. Yes.
Lords, can it be in here in the same stage? B group andre adu.
Same stage. Same stage.
Same stage.
Yes.
57.
Because everywhere, all the sajjas he has agreed, he will remove every sajja he has agreed. They have recorded that. Only the beam is the issue.
Let us see.
Very well.
57.
Yes.
Your Lordships, I have sought for modification of the interim order. Previously, this honorable court had granted an order of directed parties to maintain status quo, Your Lordships.
Now you are seeking for
whatever that I've
modification.
sought for in interim plan, not to interfere with my peaceful possession of the property. The issue being that, Your Lordship, I have put up substantial construction over the property. I have also affixed the photos, annexure L, page number 44, Your Lordships.
No, what is the deviation? Now, what is the allegation?
The allegation is that e-Khata has been issued without verifying the boundaries of the property, and also that I have encroached upon the property belonging to my neighbor. That is the allegation. But the Khata with respect to the property has been in my name since 1981. And the e-Khata was issued based on the Khata that was in my name since 1981, Your Lordships. Annexure B is the panchayat parikar.
Yes, what do you say? Instructions are completed. Petition copy you have not served.
I've served copy this morning, Your Lordship.
Then wait, we'll have to wait. Let them complete the instructions. Relist after 10 days.
A date may be fixed, Your Lordship.
Date could.
No, for almost 2 months he has.
Correct. Now you have served it now. We have to, we can hear only after they complete the instruction. Yes.
Until then, status quo order maybe.
The interim order earlier passed is extended till the next date. Yes.
58. Serial number 58, Ranganath Reddy R. Pavan Kumar.
Petitioner, Lord, challenging the order dated 5/12/2024 passed by the AE, is that annexure in page 205, my lord, refusing to grant me a sanction plan to construct my house.
You applied for sanction plan.
Sanction plan, my lord.
Now they've refused.
Refused. The reason, my lord, states that since there are many RFI cases on this particular site,
Annexure?
annexure in page 205, my lord.
Where's the endorsement?
Page number 205.
205. It is the only reason, my lord, that respondent has refused, my lord.
So you give it, now you give it to them, let them verify it.
My lord, the issue is, my lord,
there are some civil disputes.
Certainly, my lord.
Isn't it? So you produce it before them, let them take a call on that.
Lord, I produced with an affidavit, my lord, that stating that there are no stays in connection to any of the RFAs.
No, they want to have a look at the RFAs. So you produce it,
Lord,
they will.
I've annexed it along with this petition.
So you give it to them, let them take a call.
Certainly.
Then you'll have to take your stand in writing or how?
Let them meet the assistant director of town planning, my lords. Let them produce all the documents.
Petitioner to
Issue is, my lord,
appear before
Assistant director of town planning, South.
Assistant Director of Town Planning South and make his submissions regarding his objections to the endorsement before the next date. Relist the matter week after next.
Yes, we short date, my lord.
You appear before him and
I
he
will
sort
appear
it out.
tomorrow itself.
Huh?
Tomorrow or day after I shall appear. The
Relist
only
the
issue
matter
is, my
on.
lord,
No, that issue is to be decided by them. I am not going to put my head into that.
Let them appear on Monday, my lordship.
I'm ready, my lord.
Petitioner to appear before the so and so on 7th. Relist the matter on 23rd.
Obliged.
Now, if there are civil disputes, suppose title dispute is pending. Now they'll have to take a call whether they can give a plan subject to the outcome or it's not advisable. They will have to take a call. Let them take a call.
But this issue has come up only after the FTP has been filed and the civil court has already granted me the registration of my portion. And all these RFAs are pending in connection they have been filed by the other co-partners only to harass this senior citizen. Since 1987, he is fighting his civil case.
No, but now how do you get out of this litigation? Now suppose your share is allotted to somebody else.
Certainly.
That's why
All these RFAs are pending based only upon the court commissioner report. And now there was a stay which was persisting and stay has been vacated by the coordinate bench of this honorable court. And subsequent to which the FDP proceedings is completed. And most of the co-partners and the respondents they're not there, my lord, they're not able to trace the LRs. That is the reason the RFA is still pending and there is no stay in connection to any of the RFAs.
Let them take legal advice. Yes.
I'm aged 74 years, my lord, that is only grievance.
What to do?
Since 87, my lord, see,
Anyhow, you appear before them, let us.
Certainly.
Yes.
obliged.
Serial number 22. 22, Nishan.
My apologies, my lords, I was not present in the matter. My lords, this is a matter where petitioner was given an allotment letter by the MUDA in the year 1998. my lord.
Just one minute.
My counter is ready, my lord. I'll be filing it within 2 or 3 days because I've entered appearance only in January. If my friend wants to make submission, my lord,
No, file it, file it.
One submission, my lords. Similar matter, my lords, I was arguing before another coordinate bench, my lords. In such matter, my lords, the suggestion fell from the bench that if I have not made good the balance payment to the MUDA and there's a cancellation to that effect, why don't you consider paying the guideline value or the auction price?
I don't, that's between Muda and, let us see.
please.
Let them take their stand,
Please.
then we'll see. If there is some other way of dealing with it and giving concession, it's up to you. Suppose you're ready.
If my friend makes my lord, such a suggestion
Proposal.
or proposal with by a memo or some kind of an affidavit, then I can get instructions from the authority whether it could be acceptable. Such an exercise was done before the previous before the previous bench with regard to another matter, where the His Lordships have suggested that in between the guidance value and the auction price, if you put together and divided by 2, then it would be advantageous for the institution also, and the allottee would also get substantial relief. That was the
No, keep that open.
yes.
My
Petitioner,
only request at that point in time, my lords, is virtually I'll be paying the auction price or the guideline value. It should not be a conditional sale deed where I'll have to, where a lease deed would be executed for a period of 10 years.
That my lord,
I won't enter into that. Petitioner submits that he would place a proposal before the respondent for amicable resolution of dispute.
I'll file a memo to that effect.
And files a memo.
I've also indicated in the memo that the guideline value price and the auction price. Paragraph 4 at page 2, my lords.
Yeah, let us see. The authority to respond to the same. Relist the matter on
16th, 17th minutes.
good.
17.
Please.
Yes.
I'm grateful. Interim order may kindly be continued.
Interim order in operation is extended till the next date.
List number 2, B group matters. Serial number 13. Serial number 13, Abhinav R. Vivekananda.
ಯಾವುದು serial number? First list ಆಯ್ತಾ? Serial number 13, 13.
Abhinav R. Vivekananda.
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 It's a matter with regard to approval of layout plan and subsequent cancellation at the instance of the government. Lordships wanted to hear, and in fact, my lord, the state government filed memo along with some documents. But now they want to contend that the land for which the layout plan is sanctioned belongs to government and it's a government corrupt.
Let them take in writing whatever.
They have filed a memo along with documents.
So let him come with.
This matter needs to be heard, my lord, on merits.
Shall I pass over or how?
Some other day, my lord.
Some other day. Really? But what happened in Kurubralli must apply to other also.
The other matter, Lordships have disposed of.
Whatever Karab land.
But whatever said and done, my lord, as on date, in the light of the earlier writ proceedings and the writ appeal, which is confirmed by the Honorable Supreme Court, it may not be possible for the government to say it is a government land. All
point.
other issues, Your Lordship can consider.
This is the matter on date.
21st.
Yes.
Please.
Petition order earlier granted is extended till the next year.
Serial number 15, C. Shankar Reddy, Balakrishna Shastri. 15,
I sought for writ of Mandamus, Lord. There are as many as 34 petitioners.
Mandamus for
Issue of writ of Mandamus, Lord.
for what?
To consider the representations, Lord, that they have, that the petitioners have made. Insofar as issue of Akupatra is concerned.
Now you have said that some people who are ineligible have been given.
That is a different case, Lord.
Huh?
That is a different issue, Lord, not this case. In this case, there are as many as 34 petitioners. Not all of them, Lord, have been allotted sites. Lord, thereafter, Lord, revenue documents are also entered in their name. But, Lord, it requires to be computerized. Therefore, Lord, we requested them to issue computerized, Lord, Akupatras. At that particular point of time, Lord, they issue an endorsement saying that there is a computer problem, there are glitches, the computer has to be updated, only then we can issue. That endorsement, as your Lordship could see, Lord, is at Annexure J.
Page? Annexure?
Lord, Annexure J.
H.
Please, Annexure H. Annexure H, Lord, are the three representations.
No, so where is their stand now?
Lord, they have
Page?
representations, Lord, your Lordships can find.
No, that is there, but have they taken some stand? Say endorsement saying that we'll consider it later.
That your Lordships can find from page 100.
100.
Annexure J, Lord. It's an endorsement, Lord, it says, with the permission of the court, Lord, I shall read. Sri Madesh bin Kariyappa Veerapura Grama Maluru Taluku Adanavu Jilla Panchayati Taluku Panchayati ಅರ್ಜಿ ನೀಡಿ deviation ಹಕ್ಕುಪತ್ರ ನೀಡಲು ಕೋರಿರುವುದು ಸರಿಯೇ ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಸಂಖ್ಯೆ
Yes, what do you say?
My lord, kindly permit me to subject. We have filed our objections in the matter. First of all, the housing scheme, which is the Ashraya housing scheme with respect to this Veerapura Neelakanta Agrahara village, priorly. That is, Veerapura village was brought under Araleri Gram Panchayat, which is the present respondents hearing. So the said layout map produced by the petitioners, which is at Annexure C, is a layout map which was a sketch drawn by the earlier erstwhile Santehalli Gram Panchayat, my lord, not by the Araleri Gram Panchayat.
Just one minute. Now the statement of objection, you have given it to him.
Yes, my lord, we have served a copy.
Noted
it has been served on.
So now, what is your case, and then I'll take what is their stand. Now the endorsement issued.
Yes, my lord.
Is to the effect that in the website
there was a technical glitch which we have referred to the higher authorities, and it is with respect to the Rajiv Gandhi Rural Housing website, my lord. It is not something that the Gram Panchayat can take cognizance of. So we have referred it to the concerned authorities. That is the endorsement which is produced at Annexure J, dated 13/5/2020, my lord.
Yes.
So that is, so first of all, the Gram Panchayat under question here, which is Araleri Gram Panchayat, did not have any jurisdiction up till 2017. Post 2017, since we have, the village falls under our Panchayat, we have done needful. Now, whatever map that is produced was erstwhile Gram Panchayat, which is Santehalli Gram Panchayat, which has prepared that. And if your lordships takes a look at the map, the layout map has the dimensions of the sites at measuring 40/50 or 50/60. That is the site measurements that have been given, my lord. But the government circular only prescribes 30/40. We are not talking about any Sadashivnagar or any plots where you can build a villa or a bungalow over it. We are talking about the Ashraya housing scheme. So 30/40 sites are only prescribed, and here the map shows 40/50 and 50/60. And the said map is also only on the paper. Nothing has been executed in the said survey number 26, 2 acres, 28 guntas, which is the supposedly allocated layout formation area, my lord.
Now, are you redrawing it? They have been
My lord,
allotted?
we have, kindly permit me.
Been allotted?
No, my lord, that's, I'll submit my, so there is a suit pending, which is OS 5/2021, which is instituted by one K.R. Narayan Swamy against Arleri Gram Panchayat, seeking declaration and permanent injunction on this survey number 26 itself, my lord. So the suit is pending. Suit for declaration and permanent injunction. OS 5 of 2021, my lord.
Now that has to still be decided.
Yes, my lord, it's pending. And then the ownership of land at survey number 26 is with the revenue department, not with the panchayat. So here the possession has not been handed over to the panchayat. So there is no developing of land. There is no question of formation of layout according to the scheme here. It is still under process, my lord. And whatever they are saying, they have been given is ahavalu takta, which is just a list of beneficiaries. There is nothing which is conclusive, my lord. It's not a matter of entitlement just because the ahavalu takta has been issued. And even if that has been issued, it is issued by Grama Lekkadhikari, not by the panchayat. He is a revenue department official.
Yes, sir.
And my lord, that ahvalu takta is just a suggestive, list of beneficiaries. Hakku patra is the final decisive document that determines who will be the beneficiaries under the scheme. So this Hakku patra, the time is not ripe to issue any Hakku patra at this point where layout itself is not being formed and the list is not prepared yet. Moreover, my lord, the 34 people that they are referring to, out of 34, 32 are ineligible for this scheme because they have previously availed themselves under many benefits under various other schemes. If your lordship takes the objections, statement of objections at page 2 and 3, page 2 we have given.
Then why don't you?
Yes, my lord.
Why don't you consider the representation and take your stand?
My lord, we cannot consider. That's what I'm submitting, my lord. If your lordship sees page number 3, we have given under which scheme, which person who is a petitioner has taken benefit under the scheme. So if your lordship sees.
So then you take your, then you will have to, what do you say regarding that? You'll have to file your rejoinder. If you are disputing.
What is the request consideration of the sample court is all these allotment has taken place during the year 2017.
No, they're saying it's not a conclusive allotment.
Not if,
maybe
not if that is the case, not when I make a representation, not they could have given an endorsement to that effect.
My lord, it was only about the online glitch that we were discussing. The endorsement is with respect to that.
Now, anyhow, they placed it on record. They're saying that prima facie you are ineligible.
Let them not answer insofar as these representations are concerned, so that not all these persons not would be able to appear before the authorities and make out a case. If they are ineligible, my lord, the panchayat is at liberty to take decision to cancel the allotment.
My lord, they are talking about the Hakku Patra issued by the revenue department, by the Gram Lekkadhikari, not by the panchayat. We stand nowhere in this, my lord, if that is what they are requesting.
Lord, your lordships may kindly turn to the annexure H series. These representations have been made, my lord, not only to one particular department, several departments, my lord, these representations have been made. They can take a collective decision, my lord, to whether to withdraw the allotment or whether to.
No, then let us see. Then state you take your stand in writing. It's their case that they have not issued any allotment letters.
No, my lord.
It's only the revenue department. So you take your stand. Let us see.
That's the problem, my lord. They are working it.
They have not issued anything is what they are saying. What has been issued is only by the revenue department and not by the panchayat.
Lord, there is one other representation, Lord, that your lordship can find from annexure K, page 101.
101?
101. Annexure K. This has been, my lord, given to the Taluk Panchayat only. So all these departmental, my lord, requests that have been made, it indicates, at least this annexure K, K1.
So they are saying that the proposed allotment is by the revenue department, that is the village accountant, and not by the panchayat authorities.
Not allotment, as your lordships can notice from annexure A. Lord, is page 17, 17. Your lordship should notice, this is the proceedings of the year 2017. And they come up, my lord, with a agenda in the, my lord, the panchayat meeting. And they say, my lord, in survey number 26, 2 acre 28 kuntas.
So that's a resolution to make use of that extent for Ashraya sites allotment.
Thereafter, your lordships may kindly refer to the next annexure, annexure B, page 18. The panchayat, my lord, corresponds to the taluk panchayat.
Yes.
And thereafter, at annexure C, your lordships could see the sketch. What my learned friend was trying to point out is that the sites are 50 into 60 measurement. It is 30 into 25. Even the measurements are mentioned therein. Each site not measures only 30 into 25. There are small sites.
My lord, here, if your lordship sees at annexure B, it is arha ಫಲಾನುಭವಿಗಳಿಗೆ ಸಭೆ ತೀರ್ಮಾನದಂತೆ ಕ್ರಮ ವಹಿಸಲು ಠರಾವು. It is not that they have been listed and finalized and they are not eligible for any allotment as of now, my lord, because we ourselves do not have the possession. We cannot issue.
Annexure E, my lord, your lordships can find from page 21. These are all the beneficiaries. Name of the beneficiaries, my lord, are indicated therein. Thereafter, my lord, the taluk panchayat addresses a representation to the Jilla panchayat. Thereafter, annexure G series, my lord, your lordships could see in the name of each of these persons, my lord, who have been identified, including, my lord,
Now, who finalizes the list? Who finalizes the list now?
is by the taluk panchayat.
By the Taluk
Taluk
Panchayat.
panchayat. And all annexure G series, as your lordships could notice, but it is entered in their name. These documents are not at all disputed. And after issuing all this, now they want to say, my lord, that there is a suit that has been filed later during the year 2020. It is
21.
virtually, my lord, playing politics, my lord, in the village. Just because, my lord, the particular village comes under a new panchayat, they cannot change stands. That is the reason, my lord. Your lordship, my prayer before this honorable court is let there be an inquiry. If they are eligible, let them be allotted. Otherwise, no. As your lordships could notice from the prayer made in the writ petition.
No, whatever you are stating in a statement of objection,
Same thing they could have considered there, my lord.
you
Yes, my lord.
just wait. You put it in writing vis-a-vis the individual petitioners. Either they're eligible or ineligible. If they're ineligible, why? If you want clarification, you ask them. And then you give an endorsement. Let them challenge, we'll consider it in accordance with law. We are not saying that either they have a right or their list is final. The court will not comment. You consider the representation, pass orders. I will notice that you have taken your stand in your statement of objections.
Yes, my lord.
And I'll keep contentions open. You can, if you want to hear them, you can hear them and pass individual endorsements. They will take it in accordance with law.
But I think I'll have to take instructions on that, my
There
lord.
is no
Kindly
positive,
permit me to
prayer
take
that is made
instructions.
here. There is no such positive prayer that is made here.
I'll have it on Monday.
Yes, my lord.
You need not take instructions for court passing an order.
No, my lord. As in,
Nevertheless, we are only saying
yes,
we
my
are not going to comment on the entitlement of the parties. They claim that their entitlement is recognized by virtue of what you say is the revenue department. And we'll observe that and say that you have taken your stand in your statement of objection. However, to take it forward, you must give individual endorsements to them after considering the representative. I can just close it, let them, they'll challenge it in accordance with law.
Lord, they're just in the way of justice for people who are actually eligible for the Ashraya scheme because they are already beneficiaries under various schemes. That's what we have submitted, my lord. So if your lordships passes an order in this regard, again, it will lead to multiplicity of the litigation. That's all, my lord.
There is no second prayer in the writ petition. Either, my lord, I have to, my lord, get any relief that has been sought for or no. Instead of driving them to the, my lord, writ court, they could have issued such an endorsement there itself.
No, but is it a fact that you have got already, you are ineligible?
Not these, after the statement of objections are filed, my lord, I took instructions. They say it's not like that.
And then you file a rejoinder, will take note of it. If you are ineligible, no question of consideration. So far as those who are not ineligible, we'll ask them to consider. If you have taken a site under any other scheme, then you
They
are
have
not
taken,
The lordships may kindly observe that also. But if your lordship,
No, that let it be sorted out. They have taken their stand in writing is what they're saying. When did you file your statement?
my lord, 10/1/24.
January 2024, my lord.
Now you just look at R series. Each one of them, they've taken some stand. You take it in writing. You get instructions. Rejoinder to be taken, to be filed insofar as statement of objections filed as counsel for respondent number
2 and 3, my lord.
2 and 3 submit that many of the petitioners are ineligible as is evidenced from the annexures at R series.
Yes.
Relist the matter after 2 weeks. Yes.
Grateful, my lords.
17, B.B. Shivkumar, serial number 17.
For the petitioner, my lords. My lords, we are taking instruction from my client, my lords. Since it was Ramzan, so we are not able to take instruction from them, my lords. So 3 weeks time, my lords, we will.
I request, my lord. The lordships had directed the BBMP to conduct an inspection of the property. That has been done and a report has been filed, my lord.
With regards to
This is regarding tax.
There's a sanction, there's a violation of the sanction plan. Construction was done after the order has been passed, a provisional order was passed by the BBMP. At that time, only the ground floor had been constructed. Subsequently, 3 more floors have been erected. Quite a bit of violation of the sanction plan. But compound gene pillar hakputtu pillar mele 3 floor it's a 40-60 site. I am the adjacent site holder. My site is vacant. For now, my lord, me to construct it severely hampers. When the petition was pending, my lord, they have gone ahead and constructed. Now, my lord, there is an interim order by your lordships. They are sitting time. One or the other petition they seek time. I have no objection, my lord, if the time is granted. But 3 weeks, my lord, would effectively take the matter well after the vacation.
Also,
after 10 days, relist after.
Any date may kindly be fixed.
Date.
21st.
3 weeks means next roster this.
That's exactly what they.
Yes.
My lords, so entry model we extend, my lords.
Interim order in operation is extended to the next date.
18, under DPN.
Relist on 16. Next.
21, serial number 21. J.M. Patil, Sanjeev.
Yes.
Serial number 21, my lord.
List 1, list 2.
21, list 2.
Yes.
J.M. Patil.
My lord, in this matter, my lord, senior is coming.
Therefore, the petitioners. Petitioner documents are to let's kindly permit us to file additional documents. This is a PPP project, my lord, entered into between my client and the corporation after the sanction of the government. Now, my lord, just brief facts can I just narrate, my lord. So, my lord, tender was called for. We are the successful bidders in the tender. I take your lordship's rule. My lord, after the tender was called for, after we became the successful bidders, we entered into a contract. But before that, permission of the government was obtained, my lord, because it's a 20-year lease. So, my lord, anything beyond 5 years, they had to obtain. Government consented, my lord, that yes, this is a valid this to enter into the agreement. They entered into the contract, my lord, and we were asked to construct police chowkis everywhere, my lord. The modern chowkis which your lordship sees now everywhere was constructed by
was to be constructed by us at our cost. My lord, the PPP project itself was introduced by the government, my lord, because of lack of funds. So if at all anyone wants to advertise, they should invest money. So we invested lakhs of rupees, agreed, my lord, and every year about 20 lakhs amount we are depositing. Majority of the police chowkis, my lord, have been constructed by us. They have occupied it. From my side, I have kept up my word. They take advantage. There's one officer, my lord, who is creating all this mischief, my lord. Let me say that openly, my lord. They are in occupation of the chowkis constructed by me. But whereas, my lord, the display board which I am supposed to put, the benefit which is given to me, my lord, in which 15% the police can display, 15% corporation can display, 70% I can display because I've invested the money. In that, my lord, though they have occupied the chowkis, they do not, my lord, want to allow me to put up a board. That is, they don't want to keep their part of the contract. What they have done, my lord, the rules of the game they change after the game starts, and taking advantage, my lord. Now, my lord, order has been passed, despite the fact that the government has sanctioned this. Under 158, you ought to have, must obtain the permission of the commissioner before putting up the boards. Were you not aware about all this, my lord, before you entered into a contract? That too, once the government sanctions, where the question of commissioner's permission, my lord. And in the tender, they clearly say executive engineer is authorized to enter into contracts. They have entered into contracts with him, my lord. If that was the case, you should not have taken advantage of, my lord, making us construct so many police chowkis all around the town. 143, my lord, we have constructed. They admit you have constructed. We are in occupation. My lord, this is briefly. So some reason or the other, he wants to introduce one reason, and then we filed contempt against them. In contempt of court, my lord, they entered into joint agreement with us, my lord. The Honorable Court has recorded the compromise. Based on that compromise, we are asking that we obeyed the compromise. My lord, they want to violate that compromise. I have absolutely scant respect either for the contract or the law. My lord, this is the fact, my lord. And they want to take out some frivolous ground. They are using bylaw number 2018, which is not applicable, my lord. Under that bylaw itself, it says it is not applicable to PPP projects. My lord, now this is the basic fact, my lord.
What happened to the compromise of 27/6/23?
We entered into contract. That's what I'm saying. Please, you enforce the compromise which has been recorded by this court. They have no respect. They don't want to. The compromise, my lord, that's what I'm saying. The compromise was entered into, my lord, by us by order of this Honorable Court, my lord. It was recorded. That is, my lord, on 27/6/2023, Annexure F. Annexure F, page 63. Your lordships may kindly come to that. This is the joint memorandum, my lord, signed as if, my lord, the commissioner of corporation was sleeping. He was not aware about this.
Yes. Why should we adjudicate on this? You must sort it out.
Subject to correction, I don't think anyone wants to resile from the agreement. I think the issue really boils down to where these holdings are. I think that's where the divergence of opinion is happening. I don't think there's any intention to resile from the compromise agreement. The compromise agreement will be respected, will be followed, except, my lords, the question is where. So not on the footpath is what the impugned notice says. It appears, my lords, that the petitioner wants to put on the footpath, and for obvious reasons, my lords, obviously the visibility is that much more on the footpath. So, my lords, if possibly they can, what the notice says is identify suitable places, we will permit you to do it, but not on the footpath.
No,
so it really just comes down to that, my lord.
So correct. Now you have a joint meeting and sort it out. If there's something left for legal adjudication, we will enter into it. Now you have entered into a compromise. Within that, how you are going to work is have a joint meeting and you come back.
I'm open to that.
Have a joint meeting.
My lord, I'm obliged, my lord. I do understand, my lord. But thing here is, my lord, I'm being very candid. Whether I do not know whether right or wrong, one officer's ego is playing all this mischief, because when the compromise recorded by this Honorable Court, let me just point out the facts. Every place is identified. There is no question of footpath or somewhere else. Corporation doesn't own anything other than roads and footpaths. My lord, kindly see. Let me come from the compromise itself, page 63. It is just and I'll take your lordship through the impugned order. Kindly see 63, my lord. This is the memorandum of compromise. Whatever it is, I will not trouble your lordships to read the compromise decree, but kindly see, my lord, according to this compromise, we enter into a subsequent agreement, my lord, in terms of compromise. My lord, this is the compromise. Page 77 is the order passed by this honorable court. Then, my lord, the place where we are supposed to put up, my lord, is identified. Kindly now come to page number 93.
The scheduled locations.
Yes, yes. I don't mind if my learned friend is ready to make his statement. My lord will record his statement that that is the only thing we don't mind. We are ready to give him as per compromise. If you are going to honor the compromise, let him make this statement. Let it be recorded, my lord. I have absolutely, because we issue felt contempt. In that, all this happened. Now, kindly come to, my lord, Annexure L. The date is 18/11/2023. My lord, the compromise was entered into on 27/6/2023. Your lordships get, my lord, compromise entered it on, the order is passed on 27/6/2023. My lord, supplementary agreements are entered into on 28/6/2023. That is, my lord, Annexure H, page 81. Kindly see, my lord, page 81 is the agreement entered into between all of us. My lord, one simple question, my lord. Was the commissioner not aware a compromise is being entered into in the Honorable High Court in a contempt filed against him? Because I'm going to read the impugned order, my lord. It's so, my lord, juvenile type of an order that's passed. Kindly now come to Annexure L, 18/11/2023. Let me read this, my lord. This is post-compromise, post-supplementary agreement. Kindly permit me to read this, my lord. Can I read this, my lord? ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಒಂದರಂತೆ ಬಿಬಿಎಂಪಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಪೊಲೀಸ್ ಚೌಕಿಗಳಿಗೆ ಅಳವಡಿಸುವ ತಮಗೆ ಕಾರ್ಯಾದೇಶ ನೀಡಲಾಗಿತ್ತು. ಅದರಂತೆ ತಾವು 143 ಸ್ಥಳ. Did you not know where I am putting up police chowki? And 100 meters from police chowki is the contract we have entered into before this honorable court. ಸ್ಥಳಗಳಲ್ಲಿ ಪೊಲೀಸ್ ಚೌಕಿಗಳನ್ನು ಅಳವಡಿಸಿರುತ್ತೀರಿ. Let me pause here. 143 chowkis I have constructed at my cost, and the police are using it till today as I am submitting before your lordship. It is not that, my lord, something is not done. Then ಮುಂದುವರೆದಂತೆ ಉಲ್ಲೇಖ 2 ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ 6 ಸ್ಥಳಗಳಿಗೆ, ಸ್ಥಳಗಳು ಮೀನ್ಸ್ ಎಲ್ಲಿ ಕೊಟ್ರ ನೀವು? Were you given completion certificate? Were you not aware of the place where we have done? That is, my lord, 100 meters away from the chowki. And that is the contract. My lord, ಸ್ಥಳಗಳಿಗೆ ಮುಕ್ತಾಯ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನೀಡಿ ಜಾಹೀರಾತುಗಳು ಪ್ರದರ್ಶಿಸಲು ಅನುಮತಿ ನೀಡಲಾಗಿರುತ್ತದೆ. My lord, let us pause here for a moment. After the order passed by this honorable court, they have given me a completion certificate and permitted me to put my display boards on those spots. My lord, they are not aware where these spots are. This is a corporation, my lord. These are not too illiterate.
No,
Then, my lord.
Just one, no, Vikram, there's nothing to adjudicate. Now, according to the settlement, you sit across and see these were the terms of settlement agreed. If in the terms of settlement there is
I'll do that.
ambiguity, then
Only
then we will, I'll fix a date.
Very well.
Meanwhile, you sit
I'll
and
also put my best. I'll speak to that officer concerned.
finally, it's an internal agreement entered into.
Correct. And we have to honor it. There's no question of
Now
rescission.
it has become a order of the court by virtue of the compromise. So where is it that there is a difference of opinion?
I'll get instructions on that. I don't want to make any submissions.
Your lordship, just permit me for 1 second. Kindly, my lord. I want to just point out something. I have got with my lord. I obey whatever your lordship says, my lord. I'm not on that. But kindly see, my lord, page number 95 onwards. Now 95. My lord, these are the places where I have already constructed, installed. Number of panels 4. Kindly see this, my lord, where I'm supposed to install my panel. Not only that, kindly see, my lord, 100 and up to page number 98, you take advantage of the contract and you use it. And you, my lord, kindly see 137, page 97. These are the ones where they are supposed to give me now. Do you mean to say, my lord, they are not? It's all installed have completed the chowki and that is what they write. You have done your job. My lord, this is nothing short of contempt again, my lord. My lord, you can't keep on playing with citizens' rights. This is a matter of contract you have entered into. Now let me take your lordship to the impugned order now, my lord. Kindly see the impugned order, my lord. 119, your lordship may kindly come to the impugned order, my lord. Can it withstand any reasonable adjudication, my lord? Kindly see the notice. Bylaws, bylaw number 11.3. Now let me read. This is the impugned order, dated 13/9/2024. Whereas my erection, exhibition, retention, or the notice of any advertisement in any manner shall be as per provision of BBMP Act and prescribed per shall, especially section 157, 157, 158, 159 do not apply to this. That was the olden time commercial advertisement which had to be put. This is a matter of PPP. Next sentence, my lord. Whereas
now, once a compromise was entered into, all this is deemed to have been contemplated or taken note of. It is noticed.
Yes, my lord. That is the impugned notice we are called in question.
It is noticed that the parties had entered into a joint memorandum of compromise in WP 17728 of 2021, which has 21 full stop. Various issues have arisen after the respondent BBMP has issued annexure.
That is, my lord, annexure page 91, my lord.
Annexure Y.
Annexure Y, yes. Annexure Y, my lord.
Has issued notice at annexure Y.
Yes, my lord.
Noticing that there is already a compromise entered into, the respondent BBMP to take steps for amicable resolution to enable compromise to be given effect to. Relist the matter on. I'll have it after 10 days. You have a meeting. In the interregnum, BBMP to convene meeting with the petitioners and the concerned officers and take appropriate steps for amicable resolution of the dispute by the next date. Relist the matter on 10 days admin date. 16.
Negotiation
Yes. Meeting to be.
Your lordships have already passed this order for negotiation, I believe, and
Let
it's
us
been
see.
done.
Let us see. Let us see.
Well, as a final chance,
Let us see. If nothing comes out, we'll enter into it. Meeting to be convened on 8th or 9th. On 8th or 9th.
8th or 9th, my lord. 9th is also fine for me, my lord, because if they can do it within, if they can act so fast, nothing to beat that.
No, meeting on 9th.
Meeting on 8th. 8th, my lord.
On 8th. Relist the matter on 16th.
My lord, interim order is there that be continued because they have demolished 24 kiosks of mine.
Interim order in operation is extended till the next day.
It was in fact, my lord, continuous. It was not limited to any date, but it is all right, my lord. Earlier interim order was there, but by mistake, my colleague, my lord, she had made a submission and
22.
Obliged, my lord.
Petitioner's counsel.
Sorry.
My lord, the petitioner is a trust called Guru Narayana Seva Sangha Trust, my lord. Now, before, my lord, coming to the impugned order, kindly come to my lord, page number 41.
So who's the third respondent is not necessary, is it?
Third respondent not necessary. My lord, sixth respondent is a contesting respondent.
Because third respondent is an authority.
Commissioner, yes, my lord, they are the planning authority. They have to issue the commencement certificate.
So is there no standing counsel?
ಇರ್ತಾರೆ ಬಟ್ ಅವ್ರ ಅಗತ್ಯ ಇಲ್ಲ.
Huh? Not necessary. Okay, what is the matter?
My lord, kindly look at my lord page number 41. 41. Before coming to the mat, my lord, this is a photograph.
Yes.
My lord, the behind this small portion, my lord, where a man is standing, that is the convention and marriage hall of the trust. In front of that, my lord, in violation of all the laws available, the sixth respondents constructed the building. But there is an order by the Honorable Court earlier, and accordingly, my lord, the panchayat has passed an order for demolition of the construction.
By the sixth respondent.
Yes. And my lord, thereafter he filed an appeal against the cancellation of license, not against, my lord, demolition. My lord, in that, an order is passed. That order is challenged before your lordship. My lord, before coming to that, my lord, take your lordship this, I file a memo, my lord.
Now you are aggrieved by the construction of the sixth respondent.
Construction sixth respondent, and the panchayat has cancelled the license for violation and passed a demolition order, annexure B. Annexure B may be seen, ma'am. Can you look at my page number 20, my lord, annexure B. That is photograph. Yes, 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 yes. Well, annexure B is the order, page number 20. My lord,
Yes.
this was in pursuant to the order of this Honorable Court at page number 28 and 32. There was an order pursuant to which, my lord, panchayat has passed an order for demolition of the unauthorized part of the building. And my lord, he has challenged the cancellation order. Can you look at the cancellation order, my lord, at page number 25? Page 25 is a cancellation order. License was cancelled. Page 25, my lord. 25. This is where, my lord, on 15/6/2022, license was cancelled and he filed an appeal. Now, kindly look at the impugned order, ma'am. I'll read the operative portion first. At page number 15, and the operative portion is 19, ma'am. My lord, the relevant portion is paragraph 9. Paragraph 9 in the left side, my lord, 18.
Now you are a party in that proceeding?
Yes, my lord, I was a party. My lord, may I read 9, my lord? Paragraph 9.
Yes.
ಒಂದನೇ ಪ್ರತಿಭೆ ನೀಡಿರುವ ಪರವಾನಗಿಯನ್ನು ಓದಿ ನೋಡಲಾಗಿ ಅದರ ವಿಧಿಸಿರುವ ಶರ್ತದಂತೆ ಮೊದಲನೇ ಮಾಡಿ ಕಟ್ಟಡ ಪೂರ್ವ ಮೇಲ್ಮನವರು ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿ ನಗರ ಪ್ರಾಧಿಕಾರದ ಅನುಮೋದನೆ ಪಡೆಯತಕ್ಕದ್ದು. ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 45 ಮೀಟರ್ ಬಿಟ್ಟು ಕಟ್ಟಡ ಕಟ್ಟತಕ್ಕದ್ದು. ಆದರೆ ಮೇಲ್ಮನಿದಾರರು ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿರುವುದು, ನಗರ ಪ್ರಾಧಿಕಾರದ ಅನುಮೋದನೆ ಪಡೆದು ಕಟ್ಟಿಕೊಂಡಿರುವುದು, ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿಯ ನಿಗದಿತಾಂತರ ಬಿಟ್ಟು ಕಟ್ಟಿದ್ದು ಕಂಡು ಬರುವುದಿಲ್ಲ. My lord, even in violation of, my lord, national highways property, they have constructed it. My lord, then paragraph 13. ಒಂದನೇ ಪ್ರತಿ ಮೇಲ್ಮನವರಿಗೆ ಕಳಿಸಿದ ದಿನಾಂಕ 15/20 ನೋಟಿಸ್ನಲ್ಲಿ ಕಟ್ಟಡ ಪರವಾನಗಿ ಪಡೆದುಕೊಳ್ಳುವ ಸಂದರ್ಭದಲ್ಲಿ ಪೂರ್ವವರ್ತಿನ ಆದೇಶ ಪ್ರತಿ ಹಾಜರುಪಡಿಸುವುದಿಲ್ಲ. ಗ್ರಾಮ ಪಂಚಾಯತಿಯಿಂದ ಕಟ್ಟಡ ಪರ ನೀಡುವಾಗ ನಗರ ಪ್ರಾಧಿಕಾರದ ಏಕವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಸ್ಥಳದ ಪೂರ್ವವರ್ತನೆ ಮಾಡಿಸಿ ಕಟ್ಟಡ ಕಟ್ಟುವ ಶರ್ತ ಅಳವಡಿಸಿ ಪರವಾನಗಿ ನೀಡಲಾಗಿದೆ. ಈ ಬಗ್ಗೆ ಸದ್ಯ ಕಟ್ಟಡ ನಿರ್ಮಾಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಾಖಲೆ ಸಲ್ಲಿಸುವರೆ ನೋಟಿಸ್ ನೀಡಿದರೂ ಕೂಡ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ಆದ್ದರಿಂದ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಶರ್ತ ಉಲ್ಲಂಘನೆಯಾಗಿದೆ ಎಂಬಿತ್ತಾಗಿ ಕಾರಣ ನೀಡಿ ಮೇಲ್ಮನವಿ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. ನಾವು ಆದೇಶ ಮೇಲೆ ವಿವರಿಸಿದ ಕಾರಣಗಳಿಂದಾಗಿ ಪರವಾನಗಿ ನೀಡುವಾಗಲೇ ಭೂ ಪರಿವರ್ತನೆ ನಗರ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮೋದನೆ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ನಿಗದಿತ ಅಂತರ ಬಿಟ್ಟು ಕಟ್ಟಲು ಇರುವ ಸ್ಥಳಾವಕಾಶ ಮತ್ತು ಅಗತ್ಯ ದಾಖಲಾತಿಯನ್ನು ಪಡೆದುಕೊಳ್ಳದೆ ಪರವಾನಗಿ ನೀಡಿರುವುದು ಒಂದನೇ ಪ್ರತಿ ಅವಧರು ಒಪ್ಪಿಕೊಂಡಂತೆ ಕಾನೂನು ಪ್ರಕಾರ ಸರಿಯಾದ ಕ್ರಮವಾಗಿರುವುದಿಲ್ಲ. ಹಾಗೆ ಪರವಾನಗಿಯಲ್ಲಿನ ಶರ್ತುಗಳು ಉಲ್ಲಂಘಿಸಿ ಅಗತ್ಯ ದಾಖಲಾತಿಗಳನ್ನು ಹೊಂದದೆ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿಯ ನಿಗದಿತ ನಿರ್ಬಂಧಿತ ಮಿತಿಯೊಳಗೆ ಕಟ್ಟಡವನ್ನು ರಚಿಸಲು ಕೂಡ ಸಮಂಜಸವಾಗಿರುವುದಿಲ್ಲ. This is a finding of the appellate authority. My lord, thereafter, now ಹಾಗೂ ಒಂದನೇ ಪ್ರತಿವಾದಿಯು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕೈಗೊಂಡಿರುವ ದಿನಾಂಕ 31/5/20 ನಿರ್ಣಯದಂತೆ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ದಿನಾಂಕ 18/20 ನೀಡಲಾದ ಪರವಾನಗಿ ರದ್ದತಿಯನ್ನು ರದ್ದುಪಡಿಸಿ ಉರುಚಿಸಲು ಕೋರಲಾಗಿದೆ. ಈಗಾಗಲೇ ಕಟ್ಟಡವನ್ನು ಪೂರ್ಣಗೊಳಿಸಿ ವಾಸಿಸುತ್ತಿರುವುದರಿಂದ ಪರವಾನಗಿಯನ್ನು ರದ್ದುಪಡಿಸಿ ಯಾವ ಉಚ್ಚಲಿಡುವ ಪ್ರಶ್ನೆಯೂ ಉದ್ಭವಿಸುವುದಿಲ್ಲ. My lord, this is not correct. They are not residing, my lord. They are not residing there. The construction is illegal. The authorities records the finding that, my lord, it is, my lord, completed. It's not completed. Then, my lord, ಈಗ ಸುಸ್ಥಿತಿಯಲ್ಲಿರುವ ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಅಪಾಯಕಾರಿ ಕಟ್ಟಡವನ್ನು ತೆರವುಗೊಳಿಸಲು ಅಥವಾ ಕೆಡವಿ ಹಾಕಲು ಆದೇಶಿಸುವ ಹಕ್ಕು ಅಧಿಕಾರ ಪಂಚಾಯತ್ ರಾಜ್ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾಗಿರದೇ ಇರುವುದರಿಂದ ಕಟ್ಟಡವನ್ನು ಕೆಡವಿ ತೆಗೆಯುವಂತೆ ಹಾಗೂ ತೆರವುಗೊಳಿಸುವಂತೆ ದಿನಾಂಕ 4/12/20 ಮೇಲ್ಮನವಿದಾರರಿಗೆ ನೀಡಲು ನೋಟಿಸ್ ಈ ಮೂಲಕ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. Lord, finding is that, my lord, the panchayat has no power. My lord, that was not under challenge at all. Then, my lord, ದಿನಾಂಕ 26/7/24 ನೀಡದ ಮೇಲ್ಮನವಿಯ ವಿಚಾರ ಸಂದರ್ಭದಲ್ಲಿ ಮೇಲ್ಮನವಿದಾರ ಪರ ವಕೀಲರು so this is about tax. But this is the finding. After holding that, my lord, there is a illegal construction, total illegal construction. The authority comes to conclusion.
Yeah, there could be one way of looking at it.
Yes.
Now, what has been constructed pursuant to a plan is already constructed. If it is the finding that it's within the road margin.
No, it's not so much.
Road margin.
May I request you, Lord, kindly look at that photograph, my lord. This now I produced by memo.
No, so that construction, whatever it is there. Now, if it is within the road margin, let the government initiate action.
No, road margin is different issue, my lord. Kindly look at the photograph I produced. Road margin is different. But can you look at the second photograph? It is very clear. Second photograph. Now, can you look at the building? This is illegal building, total illegal building, and behind which, my lord, our convention hall is situated. So, my lord, so far as national highway is concerned, my lord, it is totally different issue. My lord, now the panchayat already passed an order for demolition. That order was not challenged at all before the appellate authority. My lord, we are very much affected. We cannot conduct any function, my lord, because of this.
So that property belongs to them or what?
Property belongs to the charitable trust called Guru Narayana Sangha Seva Trust.
No, that the property in which this building belongs to?
This property, my lord, kindly see.
It belongs to whom?
Sixth respondent. Sixth respondent. My lord, I will explain with reference to the other photograph. So kindly see, my lord, the first photograph in the memo. I can explain to Lord, my lord, how this total scenario in the spot.
Just one. Yes, Nai.
But having found that it is illegal.
No, but then how did he give a plan now?
No, plan was not given.
Just wait.
Not age mental right.
No, the,
All the violations, not only one or two, my lord.
the appeal is filed challenging which order?
Cancellation of license. Cancellation of license, page number, my lord, 25 is the order.
But can a license be cancelled after construction is put up?
No, after construction, agilla. My lord, that is not correct. No. No. Finding on this bereft of facts, my lord, it is contrary to the facts. There is no completed construction, my lord. Yes, there is an order by the Honorable Court to, my lord, to demolish. Thereafter, my lord, demolition order was passed. It is a second round of litigation. It's not the first round, my lord.
Which- Page?
Thirty-four is the last order.
The question of revoking of license may not arise, but if there is a violation of license, they are at liberty to take action in accordance with.
They have passed demolition order. They have passed demolition on annexure B, my lord.
Now, insofar as
No, revocation different. Demolition order, my lord, under section 64 of the Act. My lord,
when was the resolution passed revoking the license? Page? What was the earlier writ petition filed for?
My lord, that is at, my lord, may I submit at page number, my lord, 28.
In light of the assertion of the petitioner that there was illegal construction, writ
Yes.
petition was filed.
Yes.
7879.
Yes.
During the pendency of it, the panchayat has issued notice for cancellation of
The-
writ petition was closed. No, but now the taking of permission from the planning authority, etc., is to be insisted by the panchayat while granting the building license. Ah. Ah. Correct. So the solution would be to seek for enforcement of the conditions. You can't revoke the license.
No, the revocation is not the issue now. Revocation is not the issue, my lord. It is the demolition order. In that property, they have encroached. My lord, before the appellate authority, my lord,
Ground floor, no, ground floor question does not arise. Only the first floor plan is a subject matter of the dispute. Now, in so far as no, that
ಇಲ್ಲ ಅದಿಲ್ಲ ಆ ತರ ಇಲ್ಲ ಇದೆ my lord, he is
no, just 1 minute. Now, in so far as the defects in the plan in the first floor as made out in the notice, that you have to rectify. Ground floor is not an issue now. Now, what is an issue before the court? First floor. So now, whatever you can comply, you comply. Remaining, it's up to the authority to take action. You can't prohibit them from taking any action by challenging the resolution. Now, resolution of revoking the plan, no doubt that may have to go. They can't revoke the plan. But your building should be in adherence to the conditions imposed in the plan. So that you have to justify, and then you have to make out your case before the authority, how you are going to make out the conditions imposed in the plan.
my lord, may I, before that, because this is the third round, second round of litigation.
So correct. So what I'm suggesting.
Yes, I understood, man. May I take your last 2 minutes, my lord? What is misinterpreted, my lord? Kindly come to my lord page number. Well, I'll take only 2 minutes. Page number 37.
Yes.
My lord, this is typed portion is 39. My lord, what is the land left with him is only 2.24 cents. This is the surveyor of, my lord, National Highways stated. He has encroached upon the property. The next paragraph is, my lord, can you look at 40. Page number 40, my lord. ಅಲ್ಲ ನಾನು ಮಾತಾಡ್ತೀನಿ my lord, I have to submit. Well, I'll submit. No, I'll come to that. Let me explain. My lord, 3.4 ಅಂತ ಹೇಳ್ಕೊಂಡು ಅಲ್ಲಿ ಜಾಗ 2.4 ಮಾತ್ರ. Now kindly come to his appeal memo, my lord, at page number 43, where he is misleading the court. Paragraph, last paragraph. 23 3.41 cents ಅಂತ ಹೇಳ್ತಾರೆ. My lord, page number 43. ಕೆಳಗಡೆ ಅಲ್ಲಿರುವಂತದ್ದು 2.41 cents ಮಾತ್ರ. Now kindly come to my lord the photograph I have produced. I will be able to state.
But these are disputed.
I am not on that. I am not on that. My lord, kindly come to the photograph, my lord, which I have produced now. My lord, what was granted initially, my lord? Second paragraph, photograph, second one.
Now you want a frontage to your property.
ಅಲ್ಲಲ್ಲ ಹಾಗಲ್ಲ ಅವರು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಮಾತ್ರ ಅಲ್ಲ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಕೂಡ ವೈಲೇಷನ್ ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ. My lord, this is a house, small house in the area of 2.1 acres, 2.41 acres cents. ಇದೆಲ್ಲ ವೈಲೇಷನ್ ಅಲ್ಲಿ ಕಟ್ಟಿಯೋದು. ಇವನ್ ವೈಲೇಷನ್ ಆಫ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಲ್ಸೋ. And this is the garage, my lord. Other one is a garage. That is without license at all.
No, we can't enter into that.
That's okay. That's I'm not saying, my lord. Now kindly see, my lord, what was challenged before the appellate authority. Kindly come to my lord, page number 15. 15. My lord, first paragraph itself. ದಿನಾಂಕ 15/22 notice ನೀಡಿ. This is the cancellation order they have challenged, my lord. Cancellation of license, my lord, challenged before the appellate authority. But annexure B is the demolition order. That was not challenged at all. My lord, can you look at the impugned order now? At the end of it, the demolition order also quashed. My lord, kindly see, my lord, in the Adesha, operative portion, page number 19, last but one para, 423 ನೀಡಿದ demolition order ಅನ್ನು ಕೂಡ ರದ್ದುಪಡಿಸುತ್ತಾರೆ.
Now, when was the order of cancellation passed?
Cancellation was passed, my lord, on, kindly look at, my lord, cancellation order is passed on 15, yes, 15, my lord, 15/6/2022.
Demolition order?
Demolition order annexure B, my lord, passed on, my lord, 4/12/23. 4/12/23. My lord, challenge was only to the cancellation order.
No, but this demolition order, let us have a look at it.
Yes, annexure B, my lord, page number 20.
No, annexure B is only the notice.
No, this order, man. Yes, he has to do that. That is this one. They must have passed a resolution, my lord, before which.
No, this it appears annexure B is only subsequent to the cancellation.
Yes, subsequent. That order was not, notice was not challenged before the appellate authority. Appellate authority proceeds to quash the notice.
No, I'm prima facie subject to what all of you say. Now, if there is a license and there are certain conditions to be adhered to, it's your duty to adhere to it. If there is a failure to do so, it may not entail the revocation of license, because whatever construction you have put up pursuant to the license, but then you will be exposing to action for not adhering to the conditions imposed. And if you don't take action to rectify that, authority will be at liberty to take action to enforce conditions in the plan. And if you can't rectify it, they're at liberty to remove those deviations or whatever.
That is why notice is issued. But already there is a notice. There is a notice by the authority. Annexure B, my lord, they have already, my lord, asked him to demolish himself. Demolish on his own. He has to comply, my lord, because your lordship is ever a latest judge of Supreme Court also, my lord. There cannot be any compromise on these aspects.
No, correct. But what I'm saying is that cancellation may not be a solution.
Sir, cancellation, I'm not on cancellation, my lord. My lord, they are asking him to set right whatever he has violated. That is annexure B. My lord, cancellation, we are not on that point at all, my lord. But the appellate authority, my lord, exceeded its brief.
Now we'll read down the appellate authority's order.
appellate authority ಮಾಡಲಿಲ್ಲ.
No, what I'm saying is now the appellate authority's order will have to be restricted to the resolution for cancellation of
Yes,
license. While keeping it open to the authority to enforce the conditions to granted at the time of granting of license. And he is accountable for adhering to those conditions. If those conditions to the plan of the first floor are not adhered to, panchayat is at liberty to take action by treating it under section
64.
64. And then we dispose it of. Correct. That's why they've given. Now I'll keep it open for them to issue a notice. You will have to satisfy them, and then
They already issued a notice, my lord. The second round of litigation.
so that annexure B notice.
Yes.
You
That's-
make out a reply to annexure B notice. The order at annexure A will have to be read down only insofar as cancellation is concerned. Remaining, it's kept open. Now just take me to 64.
Yes.
In the guise of annexure A, you cannot you cannot say that they cannot take action against. Correct. Under section 64.
In the event of non-compliance with terms of notice under section so within the period of prescribed notice, it shall be lawful Gram Panchayat to take such action as may be necessary for the completion of the act thereby required to be done.
No, you go to 3.
Yes. Whenever any building is erected, added or reconstructed without such permission or in any manner contrary to the rules prescribed under subsection so and so, any condition imposed by the permission
Or
granted.
any conditions imposed
yes,
by permission
yes.
granted.
The Gram Panchayat may, whether any action is taken or not against such and so and so. Well, that's about penalty. Direct that building, alteration or addition to be stopped.
No, so in effect, Mr. Naik, you have imposed certain conditions while giving the building license. That condition you are saying is not adhered to him, isn't it? So under 64(3)(b), the notice issued will be construed to be 64(3)(b).
Yes.
Yes. Now, which is the resolution that was challenged at annexure A? No, the challenge at annexure K was with respect to
Cancellation.
ten 21 alva. Ten 21 is a resolution to cancel the license. So in effect, you have challenged that. So you are saying that it cannot be read so as to take away the right under 64.
Yes.
Isn't it?
Demolition. Yes.
Yes.
The Lordship is aware of that, my lord. My lord.
Yes, yes.
My lord, this is what, my lord, latest judgment Supreme Court. My lord, he has violated, he is not allowing us to function only. Apart from this, he is creating all nuisance. My lord, there cannot be any mercy, my lord.
The
Such kind of violators. My lord, can you look at the terms of the license, how it is violated? No conversion order.
that is. Now, where is the license? Yes, where is the license?
License is kindly, my lord, page number annexure C. ಅದರಲ್ಲಿ ಎರಡನೇ ಲೈಸೆನ್ಸ್ ಎರಡು ಲೈಸೆನ್ಸ್ 115
Page
22 my lord. My lord, kindly see page number 23. Violations 3, 9, 11, 12, 13. ಮಂಜೂರಾದ ನಕ್ಷೆ ಪ್ರಕಾರ ಕಟ್ಟಡ there is no plan at all. This is 13 my lord. Serial number 13. ಮಂಜೂರಾದ ನಕ್ಷೆ there is no ನಕ್ಷೆ at all. ಸರ್ಕಾರದ ಕಾರಣ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡತಕ್ಕದ್ದು. ವೆದರ್ my lord ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ
where is
45
the
ಮೀಟರ್.
cancellation? Where is the resolution for cancellation?
ಮಾಡಿದೆ.
The petitioner. The
My lord.
petitioner.
My lord, may I request your lordship, only one paragraph in the latest just Supreme Court, this kind of thing cannot be encouraged. Can you look at my lord?
You are right, you are right.
ಅದು ಏನಾಗ್ತದೆ ಮತ್ತೆ ಅವರು ಹೋಗ್ಬಿಟ್ಟು ಏನಾದ್ರು my lord, appellate authority exceeded jurisdiction.
That will observe that. You will have to now make out a reply to the notice at annexure B,
Within the time frame.
the petitioner has called in question the correctness of the order at annexure A passed by the first respondent. Executive Officer Taluk Panchayat. Full stop. The order at annexure A is the order passed in an appeal filed by respondent number 6 against the order resolution dated 10/8/2021 cancelling the license of the sixth respondent. Full stop. Incidentally, appeal filed under section 64(5) also calls in question notice dated 15/6/22, copy of which 15/6/22. Full stop. It is the case of the petitioner that their property is abutting to that of the sixth respondent's property, and by virtue of the construction put up by the sixth respondent, their right to enjoy the property with adequate light and air has been restricted, and that the sixth respondent is entitled to put up construction strictly in accordance with law. Full stop. It is the further case of the petitioner that the order at annexure A has the effect
Right of way also.
and right of way. It is the case of the petitioner that the order at annexure A goes beyond the scope of the appeal and has in effect injuncted the respondent number 5 from taking any action, 2 and 5 from taking any action insofar as illegalities in the construction are concerned. Full stop. It is a further contention of learned senior counsel appearing on behalf of the petitioner that the power of the local authority to take action under section 64 for non-compliance with the conditions imposed while granting of license cannot be abridged by virtue of the order at annexure A. Learned Counsel Shri Ashok N. Nayak appearing on behalf of the respondent number 2 and 5. Respondent, Learned Counsel Shri Mahesh, A.S. Mahesh appearing for respondent 2 and 5. Would submit that order of the appellate authority is taking note of the contentions of the fifth respondent, and needless to state, the order at annexure A will not tie the hands of respondent 2 and 5 insofar as illegalities in non-compliance with the conditions imposed while granting license. Learned Counsel Shri Ashok N. Nayak appearing on behalf of the first respondent is unable to controvert the contention that the appellate authority has exceeded its power while passing observations and recording findings. Learned Counsel appearing for the respondent number 6 would submit that the appeal was in effect as regards the revocation of license when partial construction is full stop. Next is to the effect
Petition 9522 of 25. Repeat on the day, Bharat DP, DHA.
the grant of license was done in an improper manner. But however, as the fifth respondent has entered into possession, the question of revocation of license does not arise. And accordingly, set aside the resolution revoking the license as well as notice dated 4/12/2023, whereby the petition respondent number 6 was called upon to remove the deviation. Next, it must be noticed that no doubt once license is granted and construction is put up, question of undoing the construction by revoking license after putting up of construction does not arise. And accordingly, the order at annexure A is to be read down to be an order prohibiting revocation of license once construction is put up. Next, it is the case of the petitioner that the action to proceed against violation of conditions while imposing license cannot be prohibited by mere allowing of the appeal at annexure A. Full stop.
Annexure B is annexure B.
Full stop. The said contention derives force from the powers conferred under section 64 upon the Gram Panchayat.
Please.
Full stop. Section 64(3) reads as hereunder.
Now it is PDO, man.
Huh?
Now it is PDO.
PDO
Two
cannot
and
abridge the
two and
cannot abridge the power of the
two and
Panchayat.
five, man. 2 and 5.
By respondents 2 and
5.
5. Full stop. Must be noticed that the sanction plan for the first floor was granted subject to certain conditions.
Plan alla, call license matra.
License, subject to certain conditions, which is enclosed at Annexure C. The action by the authorities was initiated contemporaneously with the construction of the respondent. Number 6. It is learned counsel for respondent number 6. Full stop. Respondent number 6, when has carried out construction, is required to have complied with the conditions imposed while granting the license at Annexure C. For violation of such conditions under section 64(3)(b), notice could be issued by the respondent 2 and 5. The notice at Annexure B is to be construed to be a notice issued under section 64(3)(b). The authorities respondent 2 and 5 are at liberty to issue a corrigendum notice to Annexure B, raising other grounds of violation, if any, consequent upon such action, such notice issued. Respondent number 6 to make out his reply within 2 weeks from release of certified copy of the order as annexure, as a reply to Annexure B, and within same time for any corrigendum notice if issued by respondent number 2 and 5.
Actually 2 or
Full stop. Needless to state, respondent 2 and 5 to ensure that the conditions subject to which license were issued is to be strictly enforced. The appellate order is also set aside insofar as it sets aside the notice. No, this Annexure B is not set aside.
Set aside.
Huh?
Set aside. Set aside, my lord. Kindly look at the order. Kindly look at the order, my lord. At page number 19, last penultimate paragraph, 4/12/23 ಅಂದು notice ಅನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿದೆ.
I set aside insofar as the notice at Annexure B is set aside.
ಆಮೇಲೆ findings also, my lord. Findings ವಾಸವಾಗಿರ್ತಾರೆ.
I have read down that. Needless to state, the respondent 2 and 5 are at liberty to proceed pursuant to Annexure B and subject to the observations made above to ensure that building is constructed in terms of the license and conditions imposed are adhered.
The entire process may be within time-bound limits, my lord.
Respondent 2 and 5 to expedite the process. Let us see.
ಅಲ್ಲ ಮತ್ತೆ ಮಾಡಲ್ಲ.
Expedite the process. Taking note of the expedite the process.
Outer limit.
And expedite the process and endeavor to complete the proceedings in a period not later than how many months? 6 months from today. Further 2 weeks I have given you.
List one, serial number 6.
Convention center must be visible from the highway.
ಅಲ್ಲಿ ಮಲೋಡ್ ನಮ್ಗೆ ಏನು ಮಾಡ್ಲಿಕ್ಕೇನೆ ಇಲ್ಲ, ಕ್ಲೋಸ್ ಅಷ್ಟೇ. ಆ ತರ ನ್ಯೂಸೆನ್ಸ್ ಇಸ್ ಕ್ರಿಯೇಟಿಂಗ್. ಇಲ್ಲ ಐ ಶುಡ್ ನಾಟ್ ಸಬ್ಮಿಟ್ ದಿಸ್ ಮಲಾಡ್. ಮೆಣಸಿನಕಾಯಿ ಇದು ಹಾಕಿ ಹೊಗೆ ಹಾಕ್ತಾರೆ, ನಮ್ ಫಂಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಿಡಲ್ಲ. ದಟ್ ಇಸ್ ಅ ಕೈಂಡ್ ಆಫ್ ಕ್ಯಾರೆಕ್ಟರ್.
Yes.
Serial number 60, Madhukar Deshpande, Monish Kumar.
Yes.
I was replying to the submission made by the BBMP on last date of hearing. Then the submission of the BBMP on last date of hearing was that, my lord, there is no requirement of fire NOC. That is the one submission, because no requirement of fire NOC. The reason is that, my lord, it is well below the 15 meters. Height of the building is less than 15 meters, and for that reason there is no need of the fire NOC. That was the submission made by the BBMP, my lord. And therefore any the modified plan which has been issued, whatever the condition imposed, it will not change. That it will not affect the interest of the petitioner. That is one submission made, my lord. And one more submission was made with reference to the fire NOC, that 6 meter is sufficient. That was the submission made, my lord. Lord, my submission is that, my lord, with respect of BBMP, my lord, definition of high-rising building is different. Definition of high-rising building is different, my lord. It is not with reference to the 15 meters, my lord. The bylaw number 2.46 defines the high-rising building, my lord.
No, but under the fire.
Under the fire, it is 15 meters, my lord. Whereas with respect of BBMP bylaws, my lord, it is the 2.46 is the high-rising building. 2.46, my lord.
Correct, but now the restriction of high-rise.
Yes, my lord.
Under the fire act.
Yes, ma'am.
Is less than 15.
If it is less than 15 meters, NOC from the fire department is not required, my lord. The purpose of definition of high-rising building as provided in bylaws is for a different purpose. It is in the light of the BBMP bylaws. That particular high-rising building, that definition is like this, my lord. High-rise building means a building with ground floor plus 4 or more floors above the ground floor. So numerical number of the height has not been provided in this definition. My submission is that, my lord, it is not the BBMP which can take a call regarding the what would be the height of the building, whether the fire NOC is required or not. The BBMP is not the appropriate authority, because the definition of high-rising building for the BBMP purpose is totally different. So for them, it is 4 floor or more than 4 floors. That is the definition of high-rising building. And then, my lord, with respect of BBMP, the BBMP as well as BDA and other local body, they are required to follow zonal regulations. Zonal regulation which speaks about what would be the setback area for the building. So it provides what would be the, with respect of each of the building, what could be the setback area, and they provide there is a particular table is there, and what is the requirement. If there is a high increase in the height, my lord, there is also an increase in the setback area. The purpose of the bylaws, the purpose of zonal regulation are totally different. That is with respect of the building requirement. As per the building requirement, they have specified what would be the setbacks and all those things. Whereas fire department is concerned, insofar as Karnataka is concerned, my lord, they have specifically defined what is the high-rising building. With respect of high-rising building, 15 meters and above 15 meters, that is the high-rising building, which is how it has been defined under the Fire Act, the notification which I have referred to, that is 77/2011 notification. And that particular notification says that 15 meters and above 15 meters. So my submission is that it is not the BBMP is not the competent to speak about the fire requirement. It is only the fire department which has made a submission on the basis of the report that there is no fire compliance.
Yes.
Then, my lord, I request my lords to kindly consider the fire NOC, my lord, and that was referred to by the respond number 3, as well as the BBMP, my lord, saying that the requirement is only 6 meters. The setback area is the 6 meters, and 8 meter is not required. That is annexure Q, page number 161, my lord. Page number 161, my lord, of the petition compilation.
Yes.
My lord, I request my lords to kindly take the subject, my lord. The subject reads like this, my lord. Issue of revised no objection certificate for the construction of mixed occupancy building. So this mixed occupancy means, my lord, earlier it was only a residential occupancy, and now it has been changed from residential to mixed occupancy purpose. For a moment, I request my lords to kindly take page number 82 of the same compilation. Subject, what was the subject earlier? Page number 82, my lord. Subject reads like this, my lord. Issue of no objection certificate for the construction of high-rising building. High-rise residential building. So there is a change from the residential building to the mixed occupancy building. When there is a change from the residential to the mixed occupancy building, my lord, the parameter would change. The height of all the buildings are required to be taken into consideration, and NOC of the fire department is required. And that is the reason, my lord, rightly respondent number 3 approached the authority, but after issuance of the modified sanction plan. Now, my lord, considering this particular plan, my lord, the argument was advanced by the respondent number 3, of course, by the BBMP also, that the only 6 meter was required to be left out. Page number 167, my lord. The 161 is the revised sanction plan, my lord. In the revised sanction plan, my lord, at page number 166 and 167, what is the area to be left out has been discussed, my lord.
Yes.
My lord, I request my lords to consider page number 166, my lord. In the page number 166, my lord, there is a reference in bold letter at the middle to the National Building Code, my lord. At left side column, my lord. After 2.59 open space, there is a note. After the note, there is a reference, my lord. It reads like this. As per the National Building Code 2005 Part 3, Development Control Rules and General Building Requirements, Table 2, side and rear open spaces for different height of building. Then, my lord, there is a serial number. Height of the building has been mentioned. Side and rear open spaces to be left around the building. The word building has been used there, my lord. Then what is applicable to me is serial number 9, my lord. The serial number 8 is not applicable because it is not 35 meters height, my lord. It is between 35 and 40. What is applicable to me is 40 meters, my lord. And the area to be left out is 12 meters, my lord. Then, my lord, right side, my lord. The right side in page number 166 at the top, my lord. After 3-4 lines, my lord, the maximum height of the building is, they have recorded what is the height of the building, 36.90 meters, my lord. In bold letter, above the bold letter they have mentioned. So that is the height of this particular building. And that is the reason why the serial number 9 is applicable. Then, my lord, they start discussing. Setbacks, open space required all around the building, minimum 12 meters. They have mentioned it, my lord. And then front, what is the area to be left out? All those things they have mentioned, my lord. The height of the building is 36.90 meters, for which the required setback is minimum 12 meters. All around the building, the word used is all around the building, my lord. It is not the building complex they have mentioned. Word used is building. Whereas the builder has allowed setbacks of minimum setback 8 meters on all sides under TDR provision while development right certificate. Then, my lord, the TDR certificates have been referred to. Then, my lord, at the bottom, they have discussed about FAR, TDR and setback columns, my lord. Then, my lord, plot area has been taken into consideration. Permissible FAR, my lord, 3.00 has been taken into consideration. Then permissible FAR area, that is 27,651 has been taken into consideration, that is the square meter. Then TDR has been loaded. TDR loading allowed 60%. TDR loading allowed area, they have mentioned, my lord. TDR loading allowed area have been mentioned. Achieved FAR, they have mentioned, my lord. Height of the building, once again, they have mentioned 37.20. Setback required is 12 meters. Setback required for the TDR loading. So setback required for the TDR loading is 6 meters. Setback relaxation at 50% of the total setback, 6%. Therefore, setback required is 6%. Setback provided, though the TDR, which is issued under the zonal regulation, which provides for 6%, but it is specifically mentioned that setback provided is 8 meters.
The setback required is 6 meters.
Set as per the zonal regulation, because the discussion is FAR, TDR and setback. If it is a zonal regulation, my lord, they can leave the 6 meters, but it is specifically provided for 8 meters. Then, my lord, in bold letter, my lord, they have mentioned driveway space left, proposed to provide 8 meters wide driveway all around the building from the building line with a turning radius of minimum 9 meters for the easy movement of the fire vehicles.
So this, according to you, should be maintained.
Yes, this has to be maintained all around the building, my lord, all around the building line. Now that building line itself has been changed by filing a synopsis. That particular, along with the synopsis, a sketch has been produced, my lord. My submission is that sketch does not bear the signature of anyone, not even the signature of the authority, and that particular sketch cannot be the basis. I don't know how that sketch has surfaced also. Then, my lord, with reference to this, my lord, I request my lords to kindly take the earlier occupancy with the occupancy certificate which has been issued to me, my lord. The occupancy certificate which was issued to me, my lords would find at page number 96, my lord. This is prior to the revised NOC, my lord.
Yes.
The reason why I am referring to this partial occupancy certificate is that, my lord, earlier also the BBMP has noticed the non-compliance of the requirement of the BBMP as well as fire department, and how it has been noted in this particular fire occupancy certificate, I will mention, my lord. The clearance certificate of the fire department has been noted, my lord. Thereafter, my lord, second paragraph, my lord, I will read it, my lord. The residential apartment building was inspected on 25th October 2018 by the officers of town planning section for issue of partial occupancy certificate. During the inspection, it is observed that there is deviation in construction with reference to the sanction plan, which is within the limits of regularization as per bylaws. The proposal for the issuance of occupancy certificate for the residential apartment building was approved by the commissioner on 24/11/2018. Demand note for payment of ground rent, GST, compounding fees. Then, my lord, they have received the compounding fees and security fees, late development fees of rupees so and so has been paid by the applicant in the form of so and so. The deviation effected in building are condoned and regularized. So already at the time of issuance of partial occupancy certificate, they have noticed the deviation. And once again, there is a deviation. And now the deviation is so grievous, so rigorous, and it is not at all possible, my lord. The report has been submitted that vehicles cannot move. Then, my lord, I request my lords to kindly take the next page, my lord. Page number 98.
No, but why did you take recourse to parallel remedies?
My lord, I will try to explain, my lord. In the city civil court, my lord, comes to a conclusion saying that, my lord, I am not the competent authority to decide. And he refers to various other judgment of the High Court as well as this the Supreme Court. Then he says that it is only the competent authority can decide it. And then he says that my remedy lies elsewhere. My submission is that, my lord, first of all, fire department was not a party before the city civil court, my lord. And since my lords have posed the question, I request my lords to kindly take the judgment of the district court, my lord.
Come back.
Yes. Yes. Then, my lord, with the page number 98, my lord, condition number 7, my lord. Again, with reference to the high-rising building, my lord, the fire department NOC is required if there is any change. Then, my lord, the condition number 10, my lord. Owner association of the high-rising building shall conduct 2 mock drill in the building, one before onset of summer and another during the summer, and ensure complete safety in respect of our fire hazards. Then, my lord, point number 11, my lord. Since the deviations have been done from the sanction plan while constructing the building, the security deposit is herewith forfeited. My submission is that, my lord, a repeated submission was made saying that my building has to be cut down first. Then there is a reference to the synopsis, the sketch produced along with the synopsis, saying that at the rear side of my building, a sufficient setback is not left out. And for that reason, my building has to be cut. And the person who is sitting on the branch of a tree, he himself is cutting his own branch. That is the submission was made. My submission is that, my lord, all those aspects have been taken into consideration by the fire department as well as the BBMP at relevant point of time. The deposit was forfeited. Compounding amount was taken. Thereafter, the occupancy certificate has been issued. Now, at this point of time, my lord, the builder cannot make this submission.
No, will not. That's only at the time of argument.
Yes, my lord. Because my submission is that, my lord, if the builder says that that particular building has to be cut, my submission is that immediately construction has to be stopped.
No, let us.
Yes. Now, my lord, I request my lords to kindly take the order passed by the district court, my lord. That is at page number 225, my lord, annexure V, my lord.
Now, what you are stating regarding that 8 meters.
Yes, my lord.
Is the same stand by the state.
Yes, my lord. That is the stand of the state. The state says that all around the building, 8 meters has to be left out. And all around the building complex, 8 meters has to be left out. All around the building complex, vehicle cannot move because that particular space is not sufficient. And next, in the second report, between the 2 building also, we cannot move the vehicle. That is the submission made by the state, my lord. And one next submission is that we cannot do anything because it is a civil dispute. It is the only BBMP who is supposed to intervene and they have to take the further action.
You are saying that the stand of the BBMP is not in consonance with the stand of the fire authority.
Yes, my lord. It is not.
And one of the main issues in this case depends on the fire safety.
Yes, my lord.
Which the stand of the state must be taken note.
Yes. Yes, ma'am. Because the state government is the competent authority with respect of fire issue is concerned. It is not the BBMP. Well, BBMP is only with respect of the setback.
Yes.
Then, my lord, I request my lords to kindly take annexure V, page number 225, my lord, because this particular order was referred to, though it was not read in toto. I have also not read it, my lord. Even the respondent number 3 has not read it. I will just refer to some of the paragraph, my lord. Page number 225, my lord.
The stage of the suit?
The suit, my lord, now it is posted for the plaintiff evidence, my lord. My lord, what all the issue I had raised in the suit, all those issues have been settled before this honorable court by virtue of the report submitted by the BBMP as well as the fire department. No, there are no questions to be decided in this particular suit now. By virtue of the reports which have been passed, by virtue of the orders passed by this honorable court, both the BBMP as well as the fire department have submitted the report. The issue what I had raised are already, that particular report is available before this honorable court. There are no questions to be decided in the suit.
Yes.
My lord, I request my lords to kindly take page number 225 of the petition compilation. Page number 225, my lord. Annexure V, my lord. The petitioner is the plaintiff in that particular suit, my lord. Then, my lord, who all are the party? The respondent number 3 builder is the defendant number 1, my lord. Then, my lord, the others are the partners of the partnership firm, my lord. Kindly take, my lord, next page. The BBMP is the defendant number 6 in that particular suit. The fire department is not the party in that particular suit.
Yes.
Then, my lord, the order of the points for consideration has been noted at page number 234, my lord. Page number 234. At para number 5, whether the TI can be granted or not, for that reason, my lord, 3 points have been noted at para number 5, my lord, page number 234. All these 3 points have been taken into together, my lord. Para number 7, my lord.
Yes.
Para number 7, my lord, the discussion of the contention of the parties, once again it has been recorded, my lord. Then, my lord, at para number 11, my lord, the analysis of the contention of the party starts, page number 237, my lord. I will just read it, my lord. The finding of the court in this particular paragraph, I will read it, my lord. It reads like this, my lord. No doubt, the issue regarding the violation of building bylaws and regarding the setback areas are the issue which have to be necessarily adjudicated and decided by the competent authority of defendant number 6. And this court lacks inherent jurisdiction to go into these aspects. But as the present suit is filed by the plaintiff for declaratory relief regarding their easementary right and about the alleged infringement of their civil rights due to the alleged construction put up by the defendants, this court has to necessarily consider those grievances of the plaintiff, as the defendant have asserted that they have put up the construction strictly in accordance with the building bylaws. This is the contention, by leaving the required setback area, and that their construction would not affect the rights of the plaintiff association or its members in any manner. These are all the disputed aspects are certainly required to be dealt with a thorough detailed inquiry. Therefore, undoubtedly, from the tribal contention of the parties, it could be safely held that plaintiff could make out a prima facie case for go for the merits of the trial. So in this particular paragraph, the analysis of the facts of the case or the contention, the judge starts with the lack of inherent jurisdiction to go on with these facts. Then, my lord, para number 12, my lord, the discussion with regard to the BBMP rules, my lord. Then, my lord, then para number 14, my lord, there is a reference to one particular setback area of 8 meters, my lord, at para number 14. Then, my lord, I request my lords to kindly take the para number 21, my lord. at para number 21, my lord, whether the fire agency vehicle can move and all those things have been taken into consideration. Para number 22, I may be permitted, my lord, to read. Thus, it is only after the plaintiffs proving that the alleged construction undertaken by the defendant is in contravention of the BBMP bylaws,
No,
contrary to the sanction plan.
No, but you will have to take some stand
Yes, ma'am.
before I reserve
Yes, my lord.
regarding this, which remedy you are going to elect.
I will pursue this remedy, my lord, and I will, because the court has come to a conclusion, it has given a definite conclusion that it cannot decide this particular issue. Then I have to approach this honorable court. This remedy I have to pursue, my lord.
You will have to file a memo.
Yes, my lord. Yes, my lord.
To whatever.
Yes, ma'am. Yes. I may be permitted to read this paragraph, my lord. I understand, my lord, because I cannot pursue the parallel two remedies.
I'll consider that. I'll consider that.
Yes. Yes. Thus, it is only after the plaintiffs proving that the alleged construction undertaken by the defendant is in contravention of BBMP bylaws and contrary to the sanction plan, the question of considering the alleged violation of their easementary right due to the such construction would arise. In other words, it is only after the plaintiffs satisfy that there is construction of commercial complex by defendant in violation of the sanction plan and in violation of the setback rules, the court has to consider whether or not there has been deprivation of the plaintiff's right of getting air and light by way of easement. If this is the situation, then this court, being a civil court, cannot sit and adjudicate and decide whether or not there has been violation of the building bylaws by the defendant or whether they have left the required setback or not, because it is the competent authority constituted under the BBMP Act which has to adjudicate on these issues. Then, my lord, para number 23, my lord. The same discussion continues, my lord, and the court comes to a conclusion that since the BBMP is the competent authority, it cannot consider the relief what has been sought in the temporary injunction application. Para 24, my lord, there is a reference to the Supreme Court judgment to come to a conclusion that it is the competent authorities which has to decide these type of issues. Now, para number 25, my lord, above that, para number 25, above that, my lord, the civil court has no power to go into such issues. That is the observation court has given. Para 25, above para number 25, my lord, page number 246.
Yes.
In para number 25, my lord, there is a discussion regarding Sundarraj judgment, my lord, Sundarraj judgment. Above para 25, my lord, two line, my lord, Municipal Corporation Act, and the civil court has no power to go into such issues. So the civil court has come to a conclusion that it cannot decide this issue. Then para number 25, my lord, there is a reference to the one particular judgment of this court. Then after considering all these things, my lord, at para number 26, one more judgment have been referred to. Para 27, my lord. 27, my lord. Once again, the court comes to a conclusion. I may be permitted to read para number 27, my lord. Last few lines in para number 27 at page number 248.
Yes.
248, my lord. From above para number 28, my lord, 7 lines. It starts like this. Therefore, middle portion, my lord, is instituted under the Act. Therefore, when the plain reading of the plaint averments itself clearly indicate that the plaintiff has remedy elsewhere to get resolved his dispute, which he has not exhausted, this court lacks inherent jurisdiction to go into the disputed issue involved in the suit. Moreover, as discussed supra, already this issue regarding violation of building bylaws by the defendants has been agitated by the building plaintiff association before the defendant number 6, and the concerned authority has already looked into the said aspect. Therefore, unless and until the plaintiff in this regard leads a cogent evidence, both and oral as well as documentary evidence, to show as to how the personal civil rights of the resident of the apartment complex in so and so are infringed by the offending construction and how their easementary right are affected due to such construction, this court at this pre-trial stage cannot consider the disputed issue. So this is how the court has come to a conclusion, my lord. My submission is that there is one particular inspection was done at the instance of the British Association, and the BBMP had given a certificate saying that there is no violation. Then, my lord, I approached the civil court. Then civil court did not grant the temporary injunction, saying that it has no jurisdiction and these are the disputed question which has to be decided. Did not validity. Now my submission is that, my lord, before this honorable court, BBMP has submitted its report in the form of an affidavit. Fire department has submitted its report, and both the report says that there is a violation. And my submission is that there is nothing to decide in this case now, because already there.
Correct, but it's up to you.
Yes,
you must take some stand.
This is my in the presence of my party, my lord. I am making also file one state. That particular paragraph as a brochure, what now being referred to is the brochure which is given to the present customers. This brochure was never provided to me. This brochure is part of the new customers, my lord, which is uploaded to the RERA website. And for my sanction plan, my lord, RERA was not applicable at all. At that point of time, the RERA registration was also not required. This brochure was also not required to be uploaded to the website also. So this brochure, non-production of brochure will not be a suppression of fact. And this brochure was never provided to me. Next, my lord, the submission was that sale deed was not, there is a reference to the building, that is commercial building in the sale deed, agreement of sale, deed of declaration. My lord, all these document is based upon the sanction plan. Now the question is the sanction plan, whether there is a reference to the building, commercial building. And the sanction plan, first sanction plan, there is no reference to the commercial building at all. Today also I am making the statement, they can put up the commercial building in front of my building, but as per the sanction plan, as per the independent sanction plan for the commercial building. My lords posed one specific question, my lord, to the respondents. What is the purpose of putting up a bridge between these two buildings? The answer by the builder was that, my lord, so that easily they can go to the commercial complex. My lord, we don't want to go to the commercial complex. Independently, we can go down from we will go to the ground floor, then we will go to the exit gate, and from the exit gate, we will go to the commercial building. We don't want to go from our own building, and we never sought for that also. We never requested them. The reason why they want to put the...
Can we take it broadly speaking?
Yes, ma'am.
Their insistence is on the fire safety requirements.
Yes, ma'am.
Insofar as other aspects of the plan,
yes, ma'am,
there are other remedies and it's also factual.
Yes, ma'am.
Can we take it that your main focus is on the fire safety regulations?
Yes, ma'am. Because the fire department was not the party, my lord. And for that reason, only later I came to know, my lord, this is the fire is the issue. And for that reason, the fire certificate which they have obtained is also subsequent to the modified sanction plan. Lord, my submission is that, my lord, there is one particular judgment, my lord. Of course, my lords refer to that particular judgment repeatedly with respect of other cases. That is, the Supreme Court has issued the direction also with respect of if there is a building bylaws violation. That is Justice Pardiwala's judgment, my lord. My case is, I'm just relying upon that particular judgment. And it is in the form of a direction to all the courts, and which specifically says that the building bylaws has to be adhered to. If there is any violation, my lord, it should be set it right.
There's only one point running in my mind.
Yes.
Now you can't seek for revocation or setting aside of a sanction plan.
Yes, ma'am.
The building has started.
Yes, ma'am.
If at all there are deficiencies and requirements, needless to state, you may be right to state that those deficiencies will have to be made good.
Yes, ma'am. My lord, I am not stopping their construction, my lord. I am not saying that they cannot put up the construction. Let them put up the construction. Let them leave the 8 feet, sorry, 8 meters, what is required to be left out. After leaving the 8 meters, let them put up the construction. My only requirement is that 8 meters. If they leave the 8 meters, they can let them put up any construction. And even if they bank upon my sanction plan to put up the construction after 8 meters, I have no issue. Let them take my FAR also. I have no issue. Let them take other requirement or whatever other benefit which accrues to him on the basis of my sanction plan, earlier sanction plan, let him take the benefit, but not at my cost, at my life with respect of 8 meters. I will just show one particular building, the picture, my lord. How the construction is coming up, I will just explain it, my lord.
Yes.
My lord, at the left side, my lords can see the road, my lord. Then, my lord, there is a one particular compound wall is there, my lord. Then there is a commercial building which is coming up, my lord. This is the commercial building. Kindly see, my lord, between the compound wall and the commercial building, sufficient space is available. He has left out sufficient space. Then, my lord, kindly see, my lord, the setback. What is the setback available, my lord? Completely it has been blocked. No vehicle can move here. And already he has completed one basement floor. And 2 entrances have been closed. Now we are unable to use these 2 entrance 1 and entrance 2. From the basement we are having the access to our building, my lord. 144 apartment owners, they are not using this entrance 1 and entrance 2 because completely it is blocked. And we are using the basement floor. From the basement floor we are going, my lord. Then after this particular area, my lord, he has put up a barricade, my lord. And from that particular barricade, my lord, we have to go basement floor and then we should have the access.
Yes.
My submission is that, my lord.
You're saying that 8 meters should be around the residential as well as the...
Between the 2 buildings.
Between the 2 buildings.
And the front side. Because otherwise purpose will not be served, my lord. It specifically says the front and back. So front also 8 meters has to be left out. Backside also 8 meters have to be left out. Already, my lord, in the occupancy certificate, they have already mentioned. And also in the synopsis, my lord, they have mentioned that backside the sufficient setback is not available. It is only 6.3 meters area is available for the movement of the vehicle. If from backside also vehicle cannot go, front side also it cannot go, my lord, it cannot move, then, my lord, the rescue operation cannot take place at all. And, my lord, whatever the undertaking given by the fire department, BBMP, saying that they will adhere to the requirement of the fire and fire notification, that has been completely given a go by. They have not adhered to at all.
State what is your stand? Of the existing building itself.
Fire report dated 12/7/2024 is more readable, my
So
lord,
what-
and it gives more idea.
Whatever your stand is, it's put in writing. Your stand is reflected in those reports.
Lord, I request my lords to kindly take, my lord, one report, my lord, that is 12/7/2024 report, my 12/7/2024. ಎರಡು ನಿಮಿಷ sir, ಎರಡು ನಿಮಿಷ. That is the fire department second report which they have filed, my lord. Twelve seven 2024, my lord. By way of memo dated 16/7/2024, they have filed it.
Yes.
Then, my lord, at page number 1, my lord, in a tabular form, what is the shortfall they have explained, my lord?
Yes.
The shortfall in the last column, my lord, shortfall they have explained in the tabular form, that was at the initial stage, my lord. At next page, my lord, they have provided a sketch. In the sketch also they have explained, my lord, what is the shortfall. Backside, my lord, 6.30 meters. Side, my lord, 7.60 meter, 7.65. 8 meters is not left out. Then, my lord, after the sketch, my lord, two paragraph, I will just read it, my lord. The Karnataka State Fire and Emergency Service has procured large firefighting vehicles like aerial ladder platform, which are being used to fight fire and rescue during any disaster. The required driveway and setback around the building for easy movement of the vehicle is minimum 8 meters. Since as the required setback driveway of 8 meters is not available around this building, it is difficult to conduct rescue operations during the emergency as the easy movement of aerial ladder platform is not possible. If they cannot conduct the drill, I cannot do anything. And one of the condition in occupancy certificate that twice in a year I have to conduct the drill. When the fire department cannot conduct the drill, even I cannot conduct the drill.
Yes. Single cluster.
Here also the same sanction plan needs to also sanction with lots for the same instead of 45 plan. Here instead of 11, in B, in 2, okay. This is okay. How to process of okay, I provided the same. In other words, in 1 is completed. Ashiras, you see this here. That is for 11 crores. They have no longer quarrel with regard to 11 crores. How they are trying to find for something else. This is something you must clear. Because integration what happens is B2. B2 is towards it is reduced from 11 crores to 9 crores. Modified plan from the original sanction plan it was 11 crores. It is reduced to the last by 2 crores. The 2 crores how much it is coming out? And all around they do really appreciate. But there is meters. Only one or two places. 7.60. This is not new, this is constructed. This is ready for application. Instead of 11, he is constructing 9 years. And the 2 floors is shifting here as the commercial. That is the modified plan. Which if in event it is not clear, if in event plan is from the 11 floor, still may not be able to agree. Yes, their own sanction plan. They have to agree with their own sanction plan. The virtually arguing is themselves.
This is what I'm.
Let us see.
If they are saying that it is a composite, my lord, they cannot say that I am arguing against own my sanction plan. If that is the case, why they issued the modified sanction plan?
Date code is. No, but you give an undertaking that you are going to make, leave 8 meters, there ends the matter. We'll see, we'll see. We'll see. No, we'll see. If you were to take a stand that you are going to leave 8 meters, there ends the matter. Let us see.
One submission with respect to serial number 28. In that clarification, notification of single bench order was another coordinate bench order was came to them. The clarification has been made. So in that interim order also given in this matter. Serial number 28. Maybe extended and posted for in the next week.
Interim order 28. Serial number
28.
List
2.
Interim order earlier grant is extended till the next day. Relist the matter on
Next week.
Serial number 26, my lords. Adjournment was taken, it wasn't informed to us, my lords. A date may be fixed, my lords. Serial number 26, list 2, my lords. Next week, any.
From tomorrow, I am not going to grant any adjournments at 10:30 unless memo is signed by the other side. I don't like the court being put into an embarrassment. I say you inform and inform, that's not being done. So I'm making it clear that from tomorrow, no adjournments unless you have
Serial number 20.
Yes, that's.
Date code. Date code.
Next week, and.
My lord, serial number 27.
Next week, my lords. Next week.
Serial number 27, my lord. It pertains to widening of the road without following due process of law, my lord. I request for a short date.
Preliminary hearing.
Check.
Covered, isn't it?
Covered, my lord.
Huh?
It is covered, my lord. My lord, in this, what has happened, my lord? Even the municipality authorities have given a letter to the survey department to conduct survey, my lord. Thereafter to form the road.
Short.
Serial number 27.
28th ಯಾವತ್ತು ಕೊಟ್ಟಿರಿ?
27 9th.
Sir, 28th.
28 24/4 interim order extended.
24 Thank you.
ಸೈನ್ ಮಾಡ್ಕೊಡ್ತಾರೆ. ಇದೊಂದು 27 ಅಂತ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಇಲ್ಲ ನಾ ಬರ್ತೀನಿ. 26 ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಪ್ರಕಾಶ್. ಹಾ ಇದು ನಾನೇ ಬರ್ದ್ಬಿಡ್ತೀನಿ. ಇದು ಒಂದು ನಿಮಿಷ 23ನಾ 2 weeks ಅದು. ಇಲ್ಲ ಮಾಡಿಲ್ಲ, ಗಂಗಾಧರಪ್ಪ ಮಾಡಿಲ್ಲ. 24th ಯಾರು? ಸರಿ ಆಯ್ತು, ನಿಮ್ಗೆ 24 ಕೊಡ್ತೀವಿ. 24 ಇಲ್ಲ 24 ನಿಮ್ದು 24. ಆಯ್ತು ಸರ್ ಆಯ್ತು. ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 30 2 weeks 25 ಮ್ಯಾಟರ್ ಅಲ್ವಾ, ಅದಕ್ಕೆ 2 weeks. ಹೌದು 2 weeks ಅದು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅದಕ್ಕೆ. ಡೇಟ್ 25 ಮ್ಯಾಟ್ರಿಕ್ ಡೇಟ್ಸ್ 25ನೇ ಮ್ಯಾಟ್ರಿಕ್ ಡೇಟ್ ಸಿಗಲ್ಲ. ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ರಲ್ಲ ಅದೇ ಡೇಟ್. ಇಲ್ಲ ಒಂದಕ್ಕೆ ಮಾತ್ರ ಅಷ್ಟೇ ವಿದ್ಯಾ ಅವರು 30 27 ಅದೊಂದು ಅಷ್ಟೇ. 27 30 23 ನಂದು. ಇದು ವಿದ್ಯಾ ಅವರು, ಇದು ನಾನೇ ಬರ್ದ್ಬಿಟ್ಟೆ, ಅವರೇ ಬರೀಲ್ಲ ಆಮೇಲೆ. ಅಲ್ಲ ಓದಕ್ಕೆ ಏನಾದ್ರು ಬೇಕಾದ್ರೆ ನಾನೇ ಬರ್ದಿರ್ತೀನಿ. ಓದಕ್ಕೆ ಏನು ಕಾದ್ರು ಇಲ್ಲ
ಇವಾಗ ಲೇಟ್ ಆಗ್ಬೇಕಲ್ಲ.
ಪ್ರಕಾಶ್ ಹೇಳ್ಬೇಡ ಒಂದು ಮಾತು. ಇವ್ರು ಹಿಂಗ್ ಮಧ್ಯದಲ್ಲಿ ಇದು ಮಾಡಿ ನಾನು ಯಾವ ಡೇಟ್ ಕೊಟ್ಟೆ ಅದು ಸಿದ್ಧಾರ್ಥ್ ಸುಮನ್ ನೋಡಿ ಬೇಕು ಬೇಕು ಅಂತಾನೆ ಇದು ಮಾಡ್ತಾರೆ. ಬಿ ಅಜಿತ್ 22
ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ನಾನು ಅರ್ಜನ್ ಅಂತ ಮಾಡಿದ್ದೀನಿ
ಅಷ್ಟೇ ಮೆಮೊ ಕೊಟ್ಟಿದ್ರು ಹಾಕೋದು ಇಷ್ಟು ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಾರೆ
ಇಲ್ಲ ಅಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಮ್ಗೆ ಬರ್ದಿರೋನಿಲ್ಲ ನಾವು ಹಾಕೊಡ್ತೀವಿ ಒಂದು ಮೆಮೊ ಮಾಡಿ ನಾವು ಡೇಟಾ ಕೊಡ್ತೀವಿ.
ಅದೇ 25
ಸೈನ್ ಆಗೋಗಿದೆ
ಅದು ಸೈನ್ ಆಗೋಗಿದೆ ಒಂದು ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಅದಕ್ಕೆ ಬರ್ಕೊಟ್ಬಿಡ್ತೀನಿ ಡೇಟ್.
ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಇನ್ನೊಂದ್ಸರಿ ಹಂಗೆಲ್ಲ ಮೂವ್ ಮಾಡಬಾರ್ದು. ನೀವು ಯಾವ ಡೇಟ್ ಬೇಕು ಅದನ್ನ ನಾವು ಒಂದು ಮೆಮೊ ಬರ್ಕೊಟ್ಬಿಡಿ ಬೆಳಗ್ಗೆ ಆ ಡೇಟ್ ಕೊಡ್ತೀವಿ ನಾವು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೆಮೊ ಮಾಡಿ
ಮಂಡೇ ಮೇಲೆ
ನಾವು ಡೇಟ್
ತಂದು ಕೊಡಿ
ಆಯ್ತಾ. ಅದು ಸೈನ್ ಆಗೋಗಿದೆ ಮತ್ತೆ ಆರ್ಡರ್ ಶೀಟ್
ಚೇಂಜ್ ಮಾಡಕ್ಕೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರನೇ 2 ವೀಕ್ಸ್ ಅಂತ ಆಗೋಗಿರುತ್ತೆ.
ಅದೇ ಗೊತ್ತಾಯ್ತು.
ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಗೊತ್ತಾ ನನಗೆ ಇವತ್ತು ಹೋಗ್ಬಿಡ್ಲಿ ಅದು 2 ವೀಕ್ಸ್ ಅಂತ ಹೋಗ್ಬಿಡ್ಲಿ ನೀವು ಬನ್ನಿ ಬಂದು ನನಗೆ ಮುಂದಿನ ವಾರದ ಒಂದು ಮೆಮೊ ಕೊಡಿ ನಿಮ್ಗೆ ಯಾವ ಡೇಟ್ ಬೇಕೋ ಅದು ಬಿಟ್ಟು ಬರ್ತೀನಿ ಬನ್ನಿ ಯಾವ ನಾಳೆ ಸೋಮವಾರ 22ನೇ ತಾರೀಕು ಕೊಡ್ತೀವಿ ಬನ್ನಿ ಅವಾಗ ಈಸಿ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಎಲ್ಲ ಅದನ್ನೆಲ್ಲ 2 ವೀಕ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಊರು ಮಾಡ್ತಿರಲ್ಲ. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಏನ್ ಮಾಡೋದು ಅಂದ್ರೆ ಬಂದು ಕೇಳ್ಕೋಬೇಕು. ಇವೆಲ್ಲ ಒಂದೊಂದೇ ಬರ್ತಾ ಇದಾವೆ ನೋಡಿ ಇದು ಅವತ್ತಿತ್ತಲ್ಲ ಬಂತು ಎಲ್ಲ ಒಂದೊಂದೇ ಯಾವುದು 22 ವೀಕ್ಸ್ ಅದನ್ನ ಮಾಡ್ಬೇಕು. ಹಂಗೆ ಹೆಂಗಪ್ಪ ಹಾಕಕ್ಕಾಗುತ್ತೆ ಇರೋದ್ ಮ್ಯಾಟ್ರಿಗೆ ಟೈಮ್ ಇರಲ್ವಲ್ಲ. ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು ಬೆಳಗ್ಗೆ ಕೊಡಪ್ಪ ಬೆಳಗ್ಗೆ ಕೊಡು ಅಷ್ಟೇ ಆಯ್ತು ಮೂರು. ಸರಿ ಮಾಡಿ ಸರಿ ರಿಪೀಟ್ ಕೊಟ್ಟು ಹೋಗ್ತೀನಿ. ಎರಡು ಬೀನ್ಸ್ ತಗೊಂಡು ಇದೆಯಲ್ಲ ಮೇಡಮ್ ಅದು ನಮ್ಮ ಹತ್ರ ಇದೆ ಅಷ್ಟೇ. ಫಸ್ಟ್ ಎಷ್ಟೇ ಮೇಲ್ಗಡೆ ಬರುತ್ತೆ ಅಷ್ಟೇ ಅಷ್ಟೇ ಇನ್ನೆಲ್ಲ ಸರಿ ಇದೆ ಕ್ಲೋಸ್ ಮಾಡಿ.